Live. Welcome everyone to the second day of the conference on deals and disputes, China, Hong Kong, and commercial law. This is a conference that is co-sponsored by two organizations at the University of Pittsburgh, the Asian Studies Center and the Center for International Legal Education. Today, we build on the discussion from yesterday. We begin with the first hour and a half will be our second panel of the conference. And this panel focuses on Hong Kong, Beijing, and Asian competition for dispute resolution services. After that panel, we will have a 10-minute break, and then at 9:40 Pittsburgh time, we will have our second keynote address with Anthony Daperin. The panel today, yesterday we looked at a specific case between a US party and a Chinese party. Today we look at something a bit different. We take a broader look at dispute resolution. And in Asia, as in the rest of the world, the wide ratification of the New York Convention has led to arbitration as a preferred method of dispute resolution in international commercial transactions. But the 2005 Hague Convention on Choice of Court Agreements has the potential to change that a great deal. And it has created, just as in arbitration, there has been competition with arbitration centers developing all over the world and looking to get the business of dispute resolution. It seems to be happening with courts as well. It's an opportunity for what I like to call sovereign entrepreneurship, where states look to create magnet courts to draw parties for dispute resolution services to them. And that's what we're going to discuss today. We have four panelists that I think are going to really give us an excellent set of presentations. I'm going to give a brief introduction of each of them. I won't give everything that's in the program. Everybody has that available. Take just enough time to give names and what they're going to speak about so we can get on to the discussion. Our first speaker will be Julian Chase, who is a professor at the City University of Hong Kong School of Law. He's editor-in-chief of the Asia Pacific Law Review. And Professor Chase will introduce the concept of hybrid courts and what is happening generally with hybrid courts in the region, how they compete with arbitration, and he will give some specific features of the China International Commercial Court. Our second speaker will be Zhu Qian, who's an associate professor and 100 Talents Program Fellow at Guangzhou Law School and a research associate at the Asian Academy of International Law. And Xu will speak about the China International Commercial Court, covering its structure and its functions. Our third speaker is Shala Ali, who's a professor of law and associate dean of international programs at the University of Hong Kong Faculty of Law, where she's also director of the LLM program in arbitration and dispute resolution. And Professor Ali will cover aspects of the Hong Kong mainland relationship, including investment agreements between Hong Kong and the mainland, and some coverage of what is motivating the Belt and Road Initiative. Our fourth speaker is Tiong-Min Yao, who is the Yung Pung Hao Professor of Law and former Dean of the Singapore Management University School of Law. Professor Yao will provide a country study of Singapore and how it is approaching arbitration, international commercial courts, and mediation in order to capture a piece of the pie of dispute resolution services in Asia. So that's what we have ahead. We will have each speaker speak for about 15 minutes and then have time for questions. If you have questions that you want to pose as we go along, put them in the Q&A function and we will use them when we reach the question time. So, Professor Chase, it's all yours.
So thank you. Let me begin by saying thank you and also by congratulating Professor Ron Brandt, the Center for International Legal Education and the Asian Studies Center for organizing this online event to reflect on the BRI's implications for commercial relations and the future of legal developments in Asia more generally. So I believe that today's panel addresses a set of very important topics in a fast evolving area of international dispute resolution services. And I'm delighted to participate to share with you some reflections on hybrid courts and the CICC, so the China International Commercial Court in particular. As you see, I've titled my brief presentation, International Commercial Courts as the Future of Transnational Adjudication. What I want to discuss, drawing on yesterday's session, and in particular Susan Finder's keynote, is the China International Commercial Court in the broader context of the BRI and hybrid courts development. So the key idea is that the CICC corresponds to a new stage of regulatory and economic development reached by China, which demonstrates the country's ambition to strengthen the rule of law for a number of economic transactions, which are key for the country's future economic development. So I'll start the analysis by placing the CICC in the broader context of China's economic and regulatory development, in particular, with respect to the existing domestic courts and centers for arbitration in China as well as in other BRI countries. So the first important point, I think, is to highlight the global spread of ICCs, of international commercial courts. In a world where cross-border transactions are I would say, the order of the day, parties until recently could not find recourse to international courts for cases involving cross-border transactions among exclusively private parties. It's in fact arbitration, which instead assumed the role of default jurisdiction for the resolution of disputes of cross-border transactions. So that was a gap for many years that was well identified. And the identified gap in international adjudication has eventually given rise to a new species of courts, which are these international commercial courts. So the proliferation of these courts is now well documented. A lot of things have been published, and there is a pretty rich scholarship on the phenomenon, which I'm not going to re-explain from the historical point of view. That being said, the concept of hybrid international commercial courts is, I would say, peculiar and intriguing. It's neither arbitration nor litigation before national courts. Rather, it's a combination of both. Basically, it provides the parties with the best of both worlds. Or this is the intent. The best of both worlds, that means state court proceedings and international arbitration. So generally, these courts rely on the exclusive option of a forum to support their jurisdiction, and the hybridity mirrored in these procedures is intended to represent a desirable balance between the flexibility of arbitration and, on the other hand, the greater degree of judicial obligation and guidance seen in traditional national courts. So China has also established the China International Commercial Court within the Supreme People's Court of China, with a seat in Shenzhen and a seat in Xi'an. So the concept of hybrid courts is the new emerging global trend, and China is fully part of this. Now, it's a new development worldwide, in particular very relevant to Asia. Does it mean that it's a new paradigm for the future of adjudication? I tend to believe so, and I'm going to explain why. But to address this point, it's possible to also identify a few questions that remain unaddressed or unanswered by many experts. The first question would be, for instance, whether international commercial courts really fill a gap, or whether they have been established in the hope of attracting cases that would have otherwise ended up in the ordinary domestic courts. That's something that needs to be addressed and discussed. The other big question I have in mind is that it's also interesting to reflect on whether there is any added value to these courts in comparison to the current standard way of resolving international commercial disputes, namely by way of commercial arbitration. So these are important points. How to answer that? I think the first element I'd like to highlight, as you see here, is that the international commercial courts coexist with the ordinary domestic court system, but also with other hybrid domestic and international forms of dispute resolution, like international and local arbitration, mediation, and conciliation. So the new, or the so-called new international commercial courts seem to be in the position to bridge the two systems, positioning themselves between state formal and private informal justice, despite the absence of an international legal instrument of equivalent effects as the 1958 New York Convention for Court judgments. So they are state courts, which provides them with all the advantages that are associated with state justice. And at the same time, these new commercial courts have an international dimension, providing them with some of the advantages of private justice. So in light of this, I believe that fundamentally, international commercial courts have been designed based on accumulated experience in the design of both state and private justice systems. That's why you find them in Singapore, in Dubai, and in many other places. They are new hybrid between public and private, as well as between domestic and international. That may well become the new paradigm for domestic and international dispute resolution. So in this sense, I believe that they are a new paradigm for the future of adjudication. Because while they accommodate the transition of justice from a function for citizens to a service for those willing to pay to access legal services. In fact, hybrid courts are in the position to strike a new balance in what I would call, a bit pompously, the new or the post-globalization world, by offering dispute resolution as a service in global competition, while at the same time preserving the sovereign power of the state over the adjudication of disputes. This is really the balance they try to strike. And this is what makes these new commercial courts very unique. In a nutshell, This makes them one of the very first institutions of the 21st century globalization. All these key reasons and key features suggest, in my view, that most international commercial courts are here to stay. Now, I turn my attention to the Chinese case. I think it's important to focus on the specific case of the CICC for many reasons, which combines law and economics, in short. And I have a very simple question in mind, which is whether the CICC will find an important role in dispute resolution. So I know that Qian-Chu will discuss some of the key features of the CICC. This is not what I'm going to touch upon, but I just want to launch the discussion as for the merits and the potential of the CICC, which is, in my view, a very important way to assess these courts in comparison to many others. Basically, I think that it's important now and in the near future to look at the CICC and its broader regulatory setting. Also because China is a unique laboratory for legal innovation and hybridization. The hybrid nature of China's legal system is evidenced by the use of both common law and civil law in its territory. That's something that I think I don't have to elaborate on. In this respect, the interface and interaction of the common law and the Chinese civil law system has been very much discussed in the literature from a comparative perspective. And that's something that, I'll be happy to come back on in the QA. Now, I think that the CICC also is a legal consequence of China's economic ambition. And I say ambition here. In that sense, the CICC is just part of a process from the opening up policy to now. So the CICC truly is important for China, of course, looking at hybrid courts, but at the scale of China, it's probably just a small thing in the process of China's globalization. Now, this small thing is called to grow in importance. There's a number of signals that goes into this direction. I'll mention just a few. You have here, for instance, the third plenum, which issued the decision on major issues concerning comprehensively deepening reforms, which in short allowed the market to play a more important role in resource allocation in China. Also, what's important recently to observe is that China has moved from an accrual-based system to a negative list-based system in terms of FDI, in terms of foreign direct investment, in order to ease restrictions, as the new system does not anymore require a government review for all inbound FDI. You also have very important developments on free trade zones, which I just mentioned here. And more recently, that was in June 2018, the MOFCOM, so the Ministry of Commerce and State Administration for Industry and Commerce, have implemented the one window, one form policy for registering foreign funded enterprises. So the BRI is driven by many of these reforms. And within this process, we also find the CICC. So the BRI, and that's the small thing I want to highlight here, because I'm sure many of you are familiar with this initiative. I think it's an important one, or it has to be understood as a global economic policy. It's not just something regional. It's a global economic policy because we see that there is a well-developed international legal framework that may apply to BRI projects, depending on where they are located, of course. And I think Professor Shala Ali will talk a bit about this. But due to the complex nature of construction deals, for instance, and project finance, it is envisaged that BRI will generate a number of disputes, which may be covered by the traditional investment treaties and the investor-state disputes settlement clauses, whereas some of them may fall within the ambit of domestic and transnational jurisprudence and rules. So in these circumstances, given the scale of the BRI, it has become necessary to develop China-based institutions to streamline and control the flow of these disputes. And I think that this is the main objective of the CICC. So the CICC is an instrument that is intended to help developing the BRI. I come to my conclusion, just 1 minute. So 3 points for this very simple conclusion. 3 things I want to highlight. The first one, the CICC has to be understood in the context of the BRI, and that's a specific context. And the BRI itself corresponds to a specific stage of China's engagement with economic globalization with consequences for its legal globalization. Point number 2, in fact, the CICC is the latest legal instrument which is designed to provide China greater influence and a larger role in economic globalization. That's the purpose. A goal which should be boosted by the BRI. So CICC and BRI will work together. And the last point, and I'm done, what remains important to look at is to compare these specifically Chinese developments to some other hybrid courts to fine-tune the assessment. We don't have the time. I don't have the time to do that tonight, but that's something else that needs to be done. But to do this assessment, we need to know more about the CICC. And that's why I'm pleased to close by saying I'll hand over to Tianxu to carry on the CICC. Thank you.
Thank you, Professor Shes. Good evening, everyone. I would like to start by thanking Professor Ron Brandt for his kind invitation, and also congratulate him and his center for putting such excellent program. I've been following things yesterday, and I hope to bring my own modest contribution to this program. As you can see, that my presentation will be focusing on the China International Commercial Court, which is a very important new hybrid court, so very important in the broader context of the international commercial courts, and which is also very important with respect to China's newly development. So I will focus on the CICC architecture, pitfalls, and also promises. In a nutshell, the provisions on the Supreme People's Court on certain issues concerning the establishment of China International Commercial Court became effective on 1st July 2018. So the regulations set out the scope and also the operation of the 2 international commercial courts, which is one in Shenzhen and another one in Xi'an, respectively. So the establishment of the CICC is driven by the intention to facilitate the Belt and Road Initiative and also to serve the needs of the Belt and Road Initiative, which is different from the objectives and the purposes of the Singapore International Commercial Court and also the Dubai International Financial Center. I believe that the Shenzhen CICC, which is in the Greater Bay Area, will focus on disputes involving infrastructure disputes. And on the other hand, the Xi'an International Commercial Court will focus on disputes arising from projects outlined. I think it's important to start with the CICC's objective. According to the official website, the objective of the CICC is try international commercial cases fairly and timely in accordance with the law, protect the lawful rights and interests of the both parties, the Chinese parties and also the foreign parties equally, create a stable, fair, transparent, and a convenient rule of law international business environment. To me, it means that these courts mark the first attempt of China to create a legal institution for the world as part of China's ambitions for global influence. This highlights the objective of the CICC, as we talked about earlier, which is to serve the BRI parties instead of attracting new investment opportunities for the region, for the other parties seeking to adjudicate their cases before the domestic courts, which is different from the Singapore International Commercial Court. So some of the reforms, as we can see from the China's International Commercial Court, the parties can voluntarily submit their dispute to the CICC, which could be a good starting point for China to be considered to be attractive places for BRI disputes. And the CICC was, these two courts were established under the authority of the Supreme People's Court of China, SPC. The provisions of the SPC on several issues regarding the establishment of the International Commercial Court became effective in July 1st, 2018, and SPC has now released further rules and regulations for the operation of the CICC. So these rules provide further details for about the operations of the CICC and its procedure. So the CICC rules of procedure are formulated in accordance with civil procedures of law of the People's Republic of China, and also the provisions and other laws and the judicial interpretations. As you can see that the CICC rules are rather brief, only containing 40 articles. And the CICC rules do not specify what other regulations are, like if the other laws include international arbitration rules or not. For the two courts, which they are the permanent branches of the SPC, Supreme People's Court, one in Shenzhen Guangdong Province and one in Xi'an Shanxi Province. And the full civil division of the SPC in Beijing is responsible for the coordination of these two courts. So the CICC, these two courts are part of the Supreme People's Court, the highest court in China. As from my perspective, the CICC is intended to create a one-stop dispute resolution platform, which combines arbitration, mediation, and also litigation. So the CICC is one of the most, one of the most innovative mechanism of China's initiative, given the organically integrated, which combines mediation, arbitration, and also litigation. Now let's come to the two major issues where the CICC work, the two major issues on the road ahead. The first one I'm going to talk about is the jurisdiction. Well, the jurisdiction issue, we say that because of its innovative characteristics, the CICC seems to be facing a lot of problems, or we can say challenges, which questions is availability and also capacity to function. I think that is also true that the hybrid courts, as Professor Shes mentioned in his speech, they are a relative new phenomenon, a global phenomenon. And many jurisdictions seem to be learning by doing. With respect to the CICC, these two courts, the two challenges need to be addressed. Okay, so as we know that the CICC jurisdiction is only limited to international commercial disputes. It will not deal with the international, it will not deal with international investment disputes or interstate disputes. Okay, logically, I think the most common way for the parties to submit their cases before the CICC is based on the parties' consent. And the form of the consent need to be in a written form. And this is the most common way. And the monetary value over, only for the cases, the monetary value over 300 RMB million, they can submit the cases before the CICC. And there are also less common ways for the CICC to establish their jurisdiction, which is under the referral of the higher courts or under the instruction of the SPC, if the cases have a very substantial impact on the country, within the country. So notably, the CICC is not limited to party consent jurisdiction, which may raise the concerns that the parties may feel compelled to some extent to submit mediation or arbitration. However, if you look at the jurisdiction, the articles of the jurisdiction, the peoples might find difficulties in practice to establish the jurisdiction because the first difficulty would be how to draft a valid dispute resolution clause in a contract, because there is not always a positive correlation, right, between the total value of the dispute and also the amount in dispute. So that is to say, one cannot predict the actual size of the dispute when drafting effective dispute resolution clause, so which might produce too much uncertainty. This is the first issue. And the second issue would be the enforceability of the CIC's judgments, okay, because this is also a common issue for all courts or hybrid courts. This is a major issue because from the Chinese party perspective, it is easier if the Chinese party, if one party prevails the Chinese party, but the Chinese party has a substantial assets in China, the enforcement won't be a problem because the CICC is part of the highest court. So the enforcement can be guaranteed. It might be problematic if the Chinese party has a substantial assets overseas outside of China, okay? Because we know that there is no international treaty for the recognition and enforcement of foreign judgments comparable to the New York Convention for foreign arbitral awards. So this means that if a foreign party prevailed against the Chinese party in the CICC, they may have difficulties in getting their enforcement enforced outside of China. To improve the enforceability of the CICC judgments, we know that China is party to negotiate over the Hague Convention on the recognition and enforcement of foreign judgments, and also China is considering ratifying the Hague Convention on the choice of court agreements. Okay, so come to the conclusion. The CICC represents major legal innovation in China, and it might be too early. We said it might be too early to judge whether it's going to be successful, because it seems to be a deeply Chinese court in many ways, such as the proceedings are in Chinese, subject to Chinese procedure rules and adjudicated by Chinese judges, which are also different from the Dubai International Center and also Singapore International Center, where you have a combination of the foreign judges and the local judges. There are also a number of features and characteristics that suggest a great potential for the CICC, right? For instance, the court is likely to have positive effect on the competence of the Chinese judiciary in terms of international trade and investment issues. So I think that the CICC will also have to be addressed with respect to its capacity to abide by the international standards of due process, and to what extent the parties to the dispute is truly voluntary to the court's jurisdiction. Because now if we look at the cases published by the CICC, it's not based on the parties' consent to submit the cases. They are the guiding cases issued by the Supreme Court. So if we're going to, in the future, have more case study, the cases are based on parties' consent, and we look at attitudes of the Supreme Court towards the state-owned enterprises or state-controlled enterprises, we might have a better picture about what the role of the CICC and how it's going to function within China. Thank you. Now I'm going to pass the floor to Professor Jing Yong.
All right, well, good, what is it, morning over there. It's evening here in Hong Kong. So it's a great pleasure to join you, and thank you. I just echo my thanks of my fellow panelists to Professor Brand and others at the University of Pittsburgh for organizing this multi-day conference. And to all the attendees, I see that you have a diverse range of locations represented. I was just looking through those who are participating, and it's great to see yeah, we have many jurisdictions and a lot of experience, a rich depth of experience. So I look forward to the conversation with everyone that follows. So I'm going to be focusing a bit more on Hong Kong today. And as I note from the title of the, the panel, sort of looking at competition among various jurisdictions for dispute resolution service, what I'd like to say at the outset is that you know, living here and also being in this region for some years, I noticed that what I would say is that within these regions that we're looking at today, Hong Kong, Singapore, PRC, there's quite a lot of synergy. So I would say that it's actually an expanding pie of services that are being developed in the region, rather than sort of which one is taking what. Each one, I think each of the jurisdictions that we're looking at offers very unique and very sort of complementary and synergistic services that really enhance what's available within the East Asian and within the Greater China region. And so with that, I'll just jump in. So today I'm going to talk a little bit about sort of how the BRI has influenced or contributed to further enhancement of dispute resolution mechanisms within the region. A little bit about the background of sort of what's motivating some of the reforms in terms of investment agreements, particularly from the perspective of mainland China, and looking at sort of what the direction of those future developments may take. And especially from the perspective of Hong Kong PRC relations, looking at some of the investment structures that we have in place, the closer economic partnership arrangement, I'll just touch on a little bit to give a sense of how investment agreements, newer investment agreements, are being conceived within the region. And also the role, as was just mentioned by my co-panelists, the important role of mediation, negotiation in these structures and being built into the very sort of framework of these arrangements. I'll touch a little bit on also what's unique within Hong Kong, which is the interim measures arrangement between Hong Kong and mainland China, providing for the protection and preservation of assets within the mainland through a Hong Kong court or through a Hong Kong arbitral body, which has been very well received and well used. And I'll touch a little bit on the usage of that arrangement. And I see we have someone from HKIC here joining us today, which is great. So if questions come up, I'm sure they will also be in a position to speak to that. And then a little bit about the current situation and what's happening, what's the developments in terms of the overall vitality of the dispute resolution system in Hong Kong. All right, so as some of you know, we have both the Hong Kong Arbitration Ordinance, so it's an UNCITRAL model law jurisdiction, so much of our legislation has developed and followed based on the UNCITRAL model law, party also to the New York Convention. We have a number of very prominent arbitral bodies in Hong Kong, the HKIC, CTAC, CMAC, and also the ICC has an office here as well. So as mentioned, you know, we have the BRI. What's interesting to think about, and this is something that I've found very, I know others have really focused their research on this, and this is something that I've just come to look at in recent years, is some of the impact of China's role as a net exporter of foreign direct investment, how that's really shifted its structuring of these investment arrangements in terms of protecting those investments, and how that's led also to proliferation of these new institutional arrangements. So just to give a bit of background, so in the early years, I think that it was beginning in the 1980s, these BITs were starting to become formed. And at that time, from this graph, we could see that China was really more on the receiving end of foreign direct investment rather than the exporting end. And around 2015, that role shifted, where China became, a net exporter of foreign direct investment. And so, with that shift, there was a need to rethink some of the earlier BITs and how they were structured. And also some have really attributed the growth of the BRI to sort of filling in this gap of limited protection of these earlier bits. So for example, this is an example of the 91 Mongolia PRC Mongolia bit. Disputes arising between investor of one contracting state and another shall, as far as possible, be settled amicably through negotiations. So what's the issue, what happened subsequent to this is that these bits have either been interpreted narrowly or broadly. The narrow interpretation essentially is that PRC can only seek arbitration for the amount of expropriation, but not whether or not the expropriation happened. And so that's led to difficulties in protecting rights of investors from the PRC. And so Vivian Bath and others have written about this and done some extensive work. And so these narrow clauses and narrow interpretations still survive and have given rise to complexities. And there isn't a comprehensive treaty governing these BRI countries as well. So this is some of the considerations that are being examined. So for example, here's a Senior Tsai Yapshum case versus Peru. This was an example where that dispute resolution clause was interpreted broadly so that China did have the jurisdiction to examine whether or not expropriation existed and could pursue its claim. But then we have the China Heilong Jiang case in 2010, where the Ancestral Tribunal didn't interpret that BIT broadly and said, essentially, the claimant can only look at the amount of expropriation, not whether it existed. And so the ability to sort of protect those rights were limited. So now what we see in terms of sort of forward-looking development is exploration of multilateral investment courts, rethinking how the US PRC BIT or the EU PRC BIT will be structured so that these particular investor protections will be maintained. So now I want to shift gears to look at sort of how Hong Kong and mainland have structured its sort of special arrangement for investments that take place between PRC into Hong Kong and vice versa from Hong Kong into PRC. What is the arrangement for the resolution of these types of disputes? As we know, there is a distinct sort of legal system within Hong Kong. It's a common law system. And so there is a legislative framework that accounts for investment disputes between the two jurisdictions. And this is under the Closer Economic Partnership Arrangement. And we'll just take a quick look at some of those provisions in the following slides. Essentially, the aim is to protect the investments between PRC investors in Hong Kong and vice versa. And so there are dispute settlement mechanisms in this agreement. So on the Hong Kong side, if there is a claim by a Hong Kong investor, they have a number of options. These aren't successive. They don't have to follow this particular sequence. They can choose any of the following 6, but these are the options available to the Hong Kong investor: amicable consultation, a complaint handling organization within mainland, through notification coordination of the relevant investment committee, mediation, judicial proceedings. These are all available to resolve the investment dispute. And it's very similar from the mainland side into Hong Kong. It's almost identical. Okay, so now we also see that Hong Kong is developing its own bit. So Hong Kong has a UAE bit that it recently signed in 2019. And what's interesting about this Hong Kong UAE bit is that it also provides for mandatory conciliation as a precondition to arbitration. And respondent states can require investors to attempt conciliation before the claim is brought to arbitration, but not vice versa. The investor cannot require the state to attempt conciliation. It's only in one direction. So this is a very interesting and innovative BIT, and people have commented on this. James Claxton, Luke Nottage, and Anna Ubilava have done some analysis of this recent bit and describe it as an innovative approach and an interesting integration of mediation into an investment agreement. So now we also turn to the sort of last bit of what I'll talk about today, which is sort of BRI and Hong Kong dispute resolution infrastructure. So people have sort of commented generally that the BRI has really provided very unique special opportunity within Hong Kong to be sort of a nexus point for resolution of BRI disputes. Its proximity, understanding of the PRC legal system, as well as its common law framework, puts it in a unique position to address and resolve BRI disputes. And so we have seen, in fact, a growth in BRI-related dispute resolution within Hong Kong. So we have a number of special mechanisms that have been developed. So CTAC in 2017 developed its investment arbitration rules. 2018, Hong Kong International Arbitration Center announced a Belt and Road program. We have advisory committees, databases, online dispute resolution platforms that are addressing Belt and Road disputes. And then the ICC itself also established a Belt and Road Commission in Hong Kong. So just to kind of, as I'm closing out, I'll sort of go through some of the sort of current situation. I know people are watching Hong Kong and have questions about sort of what's happening in terms of overall dispute resolution structure and recent events. So I think what's interesting to note is that in the last several years, we've actually seen a growth in cases coming to Hong Kong. So in 2020, HKIC saw an increase of about 20% in administered cases, 85% of which were international. It had 318 new filings in 2020. And I think what's interesting and sort of reassuring to note is that Hong Kong's arbitration legislation, I think, you know, as I mentioned early on, is based on the UNCITRAL model law. It's historically had a very arbitration-friendly judiciary. Most arbitral awards are respected. We have specialist judges who have a long history of support for arbitration within Hong Kong. The last point to kind of mention is a new arrangement that was set up in 2019, and some of you may be familiar with this. This is a Hong Kong PRC interim measures arrangement. And this is, I think, you know, some have mentioned that this may be driving much of the recent growth and interest in Hong Kong in terms of dispute settlement within the region. This is a very unique arrangement by which parties who select Hong Kong as a seat of resolution can have both their relief in terms of assets or evidence protected within the mainland through judgments issued within Hong Kong. And we've seen quite a number of applications for this relief, about 43, 40 for the protection of assets within PRC, 2 for the protection of evidence. And for the most part, these have all been respected and implemented. And the total amount is quite significant. I think over $2 billion US of assets have been frozen under these arrangements. So you know, the last part, I think some of you have also been following Queen Mary. It has its annual review. You know, it looks at the health of the various arbitral institutions, and Hong Kong continues to perform quite well. It's was ranked number 3 in terms of jurisdiction. And we're continuing to learn, I think, about the use of mediation, particularly in commercial and also investment dispute resolution, learning also quite a lot from Singapore. I think Singapore has made tremendous developments in institutionalizing mediation and also contributing most significantly to the Singapore Convention. So I think there's a lot of room for mutual learning and development. And I will provide that as a segue as we go into Singapore, which is our final presentation. This is actually before I end, something that we're doing now is a virtual conference. So virtual hearings are also increased. And for those who are interested, we could talk about that in the discussion. But for brevity's sake, I won't go into all of these figures now. Okay, so I will end here and happy to sort of go further into any of these aspects if questions come up. But I'm happy to turn it over now to my colleague from Singapore.
Right. Very good morning to, I believe, most of you, and a good day to the rest of you from other time zones. I want to thank the organizers for inviting me to speak at this conference. And I also want to thank my fellow panelists for being part of this team. The topic today for this session is about deals and China and Hong Kong. And I'm just going to try to explain what Singapore is doing here, right? I mean, I think we are here because we are providing some Asian competition for dispute resolution services, but not in any kind of unhealthy way. I think it was pointed out by a previous speaker that the pie is growing, and so it's really part of efforts to grow and to share the pie as such. Okay, for those of you who may not be so familiar with Singapore, a very, very brief introduction. Singapore is a tiny island which is south of China, slightly smaller than New York City. Yeah, you heard right, it's city, not state, right? Okay, population of 5.7 million with 0 natural resources. And the economy of the Singapore is almost entirely services based, right? And so basically our survival depends on services, right? Our main trading partners are China, EU, Malaysia, US, Hong Kong, and Japan. And we are a common law based legal system. Where does Singapore fit into the Belt and Road Initiative? Physically, Singapore is part of the maritime route from China into Southeast Asia and from Southeast Asia into Africa, India, and Europe. Strategically, Singapore sees itself as a financial and legal hub to service the BRI projects. And it also sees itself as an enabler of partnerships, because the people in the East often see Singapore as a gateway to the West and vice versa. So we are the ones who build partnerships for the projects. And of course, we also want to be a dispute resolution hub for BRI related disputes if and when disputes should arise. But I should say that insofar as dispute resolution is concerned, Singapore's ambitions go way beyond the BRI, of course. We just want to be a dispute resolution hub, BRI or no BRI. It's just that the BRI is there. It's good if we can deal with some of those disputes that should come out of the BRI. Now, I have no access to these figures, but this is an official statement that came out of China in 2018, that 33% of all outward BRI-related investments from China flowed through Singapore, and 85% of inbound BRI-related investments flowed into China through Singapore. So Singapore has been taking a very active role in the BRI as an intermediary, right? On the whole, Singapore is a net investor in the BRI because we already have a very strong infrastructure. We don't need any external investments for that, but we do invest in the infrastructure of other BRI countries, especially China itself, right? And okay, I want to say a bit more about the Dispute Resolution Hub because I think that is the core of the interest of this session. Now, as far as Dispute Resolution Hub is concerned, the ambition of Singapore is to be a one-stop dispute resolution hub because we see that there are different reasons in different kinds of disputes involving different kinds of parties why certain types of dispute resolution may be preferable to others. And so we want to build a system where, well, you know, we can sell ourselves as a neutral platform for dispute resolution. It's a service that we are offering to the rest of the world. The arbitration is something that we've been doing for quite a number of years already. The International Arbitration Center was set up in 1991, and by all accounts, is doing quite well today. And the Singapore International Commercial Court was established in 2015, and I will say a little bit more about this in a moment. And at around the same time, the Singapore International Mediation Center was also established. Now, it's no coincidence that these happen at roughly the same time because these are really state-driven enterprises, right? It's really a vision for Singapore to become a Asian or perhaps even global dispute resolution center, and government resources and being invested to build that vision in partnership with the private sector, right? Because if you want to be a global player in the dispute resolution scene, you must be part of the global network, right? And we see that as something very, very important, which is why we are part of the New York Convention. Our arbitration rules are based on the UNCITRAL model law and so on, right? And as far as the International Commercial Court is concerned, we understand the significance of the international framework, and that's why we signed on to the Hague Convention on the choice of court agreements, and we are already starting to see cases coming under the convention, right? And the Singapore International Mediation Center, the convention, to support it, the Singapore Convention on Mediation is still very new, but it's already law in Singapore. And basically, what we want to see is an international legal framework for different kinds of dispute resolution, of which we can be a part and thereby play a significant role in offering these services. Okay, I will say a little bit more about the International Commercial Court because I think that that is probably of greater interest in this forum here. Now, the Singapore International Commercial Court is really a division of the Singapore Supreme Court. So constitutionally, it is a court of Singapore, okay? But it is set up to do something different. It's international and commercial only in the kind of work that it's intended to do, right? It's not a real international court, it's a Singapore court doing international work, okay? So it has jurisdiction in international and commercial matters. It has three bases of jurisdiction. The first, and the primary model is the jurisdiction based on parties' agreement, right? This is modeled after the arbitration agreements for the New York Convention, okay? But beyond that, it also has jurisdiction in international commercial arbitration matters. In the judicial support for supervision, interlocutory orders, and enforcement, the SICC will hear these cases, right? And part of the reason for giving it that jurisdiction is because this court has that international perspective, international experience, and therefore most suited to deal with these kinds of problems. Okay. It also has jurisdiction in matters which are transferred to it by the normal Supreme Court of Singapore. And the reason for this is that you need to start giving the court business. Between the time when you tell people there's such a thing and please draft a choice of SICC clause and the time when cases start coming in is going to be a number of years. It takes time for people to draft the clauses, get into contracts. It takes time for disputes to arise from these contracts, right? So in the meantime, you just get the institution going, right? And you start giving it cases, which are of course international and commercial. We already do get a lot of international commercial cases coming into our courts anyway, right? So it's just a matter of transferring those cases to be heard by the International Commercial Court. Okay, the SICC is a very good example of what Julian mentioned just now as a hybrid court, because it was designed to incorporate certain features of arbitration into it. And these are some of them. In appropriate cases, foreign lawyers can argue. And one of the reasons why that's there is that we've learned that if lawyers from foreign countries cannot argue, they have no incentive to draft in the choice of court clause. Okay, right. So the parties can also adopt rules of evidence, which are different from the normal rules of evidence applied in our normal courts. The document production rules are more similar to arbitration proceedings than to the discovery proceedings in litigation. Counsel can submit directly on foreign law without calling on experts with affidavits and testimonies and so on. And in appropriate cases, parties can actually seek confidentiality of the proceedings, right? And we have a panel of international judges. Last count, there were 16 of them, a majority of them from the UK, some from Australia, and one each from Hong Kong, India, Canada, the United States, and France, right? But one important thing to note is that unlike an arbitration, the parties cannot choose the judges, right? The judges will be assigned by the court. And although it's a hybrid court, I think we need to draw the line somewhere. We need to maintain the institutional structure and integrity of a court of law, okay? And foreign lawyers, as I said, are allowed to argue in the SICC. And last I checked last week, we had 86 foreign lawyers registered with the court. These are people who will be able to argue before the SICC from a total of some 17 jurisdictions. And I think about 6 of them are from the United States. Okay, right. Now, this is a survey that I think most of you are very familiar with. Shala made some reference to it. It's the International Arbitration Survey conducted by Queen Mary University with White and Case. And in the last survey, you can see that Singapore and Hong Kong are in the top 3 in terms of preferred seats from respondents in all regions, and also from respondents in the Asian Pacific region. Again, you see Singapore and Hong Kong in the top 3, right? Well, sometimes Singapore gets ahead of Hong Kong, sometimes Hong Kong gets ahead of Singapore. It's a very kind of friendly sibling rivalry, right? But I think this is an indication of the kind of work in arbitration that Singapore and Hong Kong are doing in terms of servicing the international commercial community. In most cases, in terms of whether Singapore is ahead or Hong Kong is ahead, I think the phrase you use in these parts, in your parts of the world, is too close to call, right? I think that's the level of competition we are talking about. Okay. Now, next, I just want to speak very briefly about another survey, which I think many of you may not be very familiar with, because this is a new survey. This is the first survey done, the first report of this survey, and it's conducted by the Singapore International Dispute Resolution Academy, which happens to be housed in my university, the Singapore Management University. And the reason why it's doing a survey is that the Queen Mary White and Case survey is focused on arbitration. And it was felt that there is a need to have a broader based survey on dispute resolution more generally. Okay, and this is the first report. And it's more modest compared to the Queen Mary survey, 304, just over 300 respondents from 46 countries, but it's the first run. It's also running again right now. Some of you may have received the survey questions from them, right? And just a couple of snapshots of findings from this survey. The first is not much of a surprise. What is the preferred dispute resolution mechanism from the respondents? Well, arbitration is still the top choice, right? Litigation follows, not all that closely, but it's a clear second, right? And then followed by hybrid mechanisms like the combination of arbitration, mediation sort of thing, and then finally mediation. So at this point in time, the sentiment seems to be that, well, mediation is not all that popular for commercial parties at the moment, but it's something that we are monitoring. It's something that I think the pattern will change as we progress. Okay, another snapshot is what is the most commonly used international courts from the respondents, and perhaps not surprisingly, the responses, the top two most commonly used international commercial courts from the first survey, the London Commercial Court and the Singapore International Commercial Court. I think we need to read this with some care, because the question is not what is your favorite court, right? The question is what is the court you use the most, right? And the London Commercial Court is I mean, I think there's no question that it is considered the most popular commercial court at the moment, right? And the Singapore International Commercial Court is there as number two, I think partly because it's been around for a number of years, but I think we need to be mindful that most of the cases that is heard so far are not cases where parties have chosen the Singapore International Commercial Court, but cases which have been transferred to the SICC by the normal commercial division of our Supreme Court. Okay, and Hong Kong doesn't feature here because people don't think of the Hong Kong court as an international commercial court, and not because it doesn't do international work, but it's not marketing itself as an international commercial court, right? And so maybe there's a bit of work for Hong Kong to do there, but clearly, I mean, this is limited information, right, in terms of what kind of interpretation that we can put on this kind of question. But I think in the years to come, we will probably pick up more and more interesting data when people are more used to the idea of international commercial courts, and when you get more and more disputes going into international commercial courts now. And I look forward to more data, useful data coming out of this kind of survey. And that's all I really want to share with you today. I'm happy to address any questions that you may have on Singapore, from now. Thanks.
Thank you to all of our panelists for what have been very substantive and thought-provoking presentations. And we do have questions coming in. And I'm going to start with one that is a question within the panel from Julian to you. And that is with the MOUs that China is signing on the Belt and Road Initiative, do they require that BRI-related disputes be submitted to the China International Commercial Court? You are muted, Hugh.
Oh, hi. Yes.
Okay.
Okay. I'm going to take the questions on the China's International Commercial Court and how the first question, how the CICs are certain foreign law. Sorry, Professor, I couldn't hear you.
Yes, that one, and as well, Julian put a question in the chat privately and is wondering about MOUs China is signing with BRI countries.
Oh,
what do they
okay.
require in terms of, do they require that disputes be submitted to the International Commercial Court?
Okay, thank you. Thank you for the questions. Now I'm going to address the first issue, how the CICC will ascertain the foreign law. So according to the rules of the China International Commercial Court, especially for Article 10.1. Article 10.1 of the Laws of the People's Republic of China on the law applicable to foreign-related civil relationship prescribes that foreign laws applicable to foreign-related civil relations shall be ascertained by the People's Court. And arbitral authority or administrative agency. If any party chooses the applicable foreign laws, he or she shall provide the laws of the jurisdiction in question. So for the CS in practice, both the courts and the parties, at the guidance of the court, they can entrust and have entrusted the BCI or the BIMC, which a third-party authority, independent authority. In most of the situations, the BCI and the BIMC is entrusted by the parties, who choose applicable law, foreign law, and therefore need to ascertain the foreign law. With only a small amount of cases is entrusted by the court. Now, due to the procedural issues in litigation, and usually the fees are bared by the parties. And as for the progress of China's intention to ratify the Hague Convention on the Choice of Court Agreement, and we see that they are progressing, but we don't know when they're going to make further development on this front. And for the second issue, is whether the MOUs that China is signing with BRI countries require that their related disputes be submitted to CICC. I would say this is a very good question. The CICC will not have automatic jurisdiction, okay, over the Belt and Road Initiative related disputes. The parties in the BRI projects will have to select the CICC, okay, in the dispute resolution clauses of their contracts or agree to agree to submit the cases on case-by-case basis. So I just want to stress that foreign parties may not want to have their disputes with Chinese parties heard by Chinese courts because they might question the independence and impartiality of the Chinese court. So they may not want their disputes to be heard or to be decided based on especially Chinese law, so which is relatively unknown outside of China.
Okay.
I hope I answered your questions.
Yeah, I think that was helpful. I'm going to go to Shala here. If parties choose Hong Kong, Peter Truboff has a question here. If parties choose Hong Kong for arbitration, the interim measures agreement, can they exclude the applicability? I would assume that you've indicated that Hong Kong, that seems to be a draw for Hong Kong dispute resolution to have the interim measures agreement because you can get security of assets in the mainland, but is it possible for parties to exclude the applicable of the interim measures agreement as well?
Yeah, no, that's a great question. I haven't heard of cases where, a party has asked to exclude. I'd imagine, given that, arbitration is the creature of contract, it's very much a contractual beast, a party could do what they wish, in terms of their agreements and what they opt in or opt out of. But like you said, Professor Brand mentioned, it's really an attractive feature, and I think something that people wouldn't want to deprive themselves of, because it really gives you an ability to sort of access, just as a court could access these resources and protect or preserve evidence, for example. So yeah, it would be hard to think of a situation. Perhaps the question Peter could give some maybe examples. But I can imagine that it's possible to sort of opt out. We do have a member of HKIAC here, so we can maybe circle back to this. But I'd also be happy to hear maybe some examples of, how a scenario where this could be helpful. So that could give me some idea of how that could be structured.
What about the question of security? Does a party requesting interim measures under the agreement have to provide security in the event that they are unsuccessful on the merits?
So there's a great write-up, and I'm happy to put it in the chat. There's a fantastic write-up on this interim measures arrangement. It's like 3-4 pages. So if it's okay, I'm going to send it through, and hopefully those who have these questions can sort of look through it. I'm not an expert in it, but I do have a basic understanding that, yeah, courts will scrutinize the sort of requests, but in general, I'd say the majority of those requests have gone through, and their security, I believe, is covered in this write-up. So I will send it through in just a minute. And when I do, I think everyone can see it. So if I have trouble putting in an attachment, then I will come back and find another way to send that through.
Thank you. I'm going to go back to the question on ascertaining foreign law, and I'm going to ask that more broadly. And Tiong Min, maybe you can answer on Singapore as well. To the extent that the various courts that we talked about are chosen, it's one thing to choose the forum, it's another thing to choose the law. So does the CICC require that when it is chosen as a forum, the applicable law be Chinese law? And if not, how do they determine and ascertain the foreign law? Same question, Tiong Min, in Singapore.
Thank you for your question, Professor. In most of the cases for the China-related foreign civil or civil or commercial matters, they choose, in most of the cases, 99% of the cases, they choose the Chinese law as the applicable law. So that is also one of the concerns for the foreign parties, because they are unfamiliar with the Chinese practices, with the Chinese law, and especially, and also with the interpretations of the Chinese law. Because according to the assessment of Chinese laws in the CICC, they also say that the disputes will be also resolved with other laws or regulations. And we don't know what other laws or regulations are, and we still don't know. We are still uncertain about whether they're going to, in accordance with the general practice or international standard. Thank you.
Good, thank you. Tiong Min in Singapore?
Yeah, well, the SICC is a division of the Supreme Court, so it applies the private international law of Singapore. And the private international law of Singapore is very, very pro-party autonomy. As far as contracts are concerned, parties are free to choose any law they like, so long as it's not against public policy. And the law that they choose need not have any connection with Singapore. The law that they choose need not have any connection with the contract. It's the idea of neutral law. And because it was designed to deal with international disputes, it is expected to deal with all kinds of questions of foreign law. And that is one of the reasons behind having international panel of judges, some of them from civil law backgrounds as well.
that brings us to the question of how those judges are chosen or appointed and how they are assigned to a case. You indicated that unlike arbitration, you can't choose your judge, but are they just randomly assigned? And are judges, if for example, if UK law was chosen, would there be certainty that a UK judge would be on the panel?
Well, okay, I cannot answer this question with certitude because I don't know what actually happens in the courts in terms of the assignment. But from what I see coming out in the cases, if it's a matter that calls for the application of UK law, as far as I can see, so far it's been the UK judges who have been assigned to it. So there is that empirical pattern, right? But I cannot tell you what the rules are because I have no idea in terms of how they actually assign. But I think from a very commonsensical perspective, they will assign judges based on their experience. It's no different from a situation where you have, if in the domestic case, you can have a shipping case, you can have a tort case, you can have a criminal case, and judges are assigned based on their experience in those areas. And I think it's no different when it comes to the applicable law.
Okay. There have been some questions.
Ron, sorry, can I add something here?
Yes.
Quick
sure.
comment. That's Julien. Sorry to interrupt. Well, I think colleagues gave very good clarifications on the question of the applicability of foreign law. I just want to add two very small things to complement the answers. The first element is that in the case of the CICC, as Chen Xu said, the CICC judges are to be Chinese. They are to be Chinese nationals, but there is a commercial, an international expert committee consisting of Chinese and foreign legal experts that was constituted under the CICC, and our colleague and friend Susan Finder is on this committee. So it's important to mention this because these legal experts are retained primarily to assist the judges, the Chinese judges, in ascertaining the content of foreign laws. And here there is a link between the origin of the judges, how they are assisted and advised by experts with respect to the applicability of foreign law. And the second quick point I wanted to make on the applicability of foreign law at the CICC, sorry, even if it's marginal, there are some little innovations that I have noticed recently. In 2019, the CICC launched the so-called Foreign Law Settlement Platform, which is intended to assist the people's courts at all levels, parties, counsel, and so on, in the exercise of dealing with foreign law as applicable law. I'll put the link in the chat box so that all the colleagues, including those asking the question at the beginning, can access this new website.
Thank you. There is a question about the choice between arbitration and litigation and how international commercial courts are influencing that. Now, and Julian noted the kind of the hybrid nature of international commercial courts. And it's going to take some time, as Jung Min mentioned, because parties have to put the clauses in their agreements, and then the disputes have to arise. But can you comment a little bit on the choice between arbitration? Some of you have addressed it, but a little more specifically on, would you advise parties today to choose arbitration in Hong Kong or litigation in Hong Kong, or arbitration in China or litigation in the CICC, or in Singapore, arbitration or the Singapore International Commercial Court?
Can I try to answer this question? It's a very good question. Okay, well, I'm sharing the website in the chat box. I would say that with the new hybrid courts, there is a number of let me call them promises, which are very interesting. And they come in contrast with some of the shortcomings of arbitration that we can observe over the last 10 or 15 years, such as over-formalization, delays, rising costs, concern about legitimacy. So these kind of negative elements or shortcomings are real. They have a different importance depending on whether you look at London, Singapore, Hong Kong, or some other places, but they have been around now for some time. And in light of these, the hybrid courts provide with an alternative and a solid options. Now, does it mean I would, because that's your question, recommend parties to go for hybrid courts as opposed to arbitration? I think you got me on that, you trapped me on that, because I would remain cautious for the time being. Hybrid courts generally provide some degree of party autonomy, but not to the extent provided for in arbitration. And that's something that Shala insisted on, and I think she's right. There is less flexibility in the context of hybrid courts than arbitration, for instance. And sincerely, I think that may be a concern for many councils and many parties. Many may still be attached very much to this high flexibility granted by arbitration. So, to wrap up on that, I think that hybrid courts are the new kids on the block. They have a potential, which is, I think, genuine, that cannot be discussed. But that's going to take some time for them to replace or take some shares of the arbitration cases that are going to remain around for some time.
Thank you, Julian. Others on that question?
If I may, yeah. Okay. I think that there is still a very strong preference for arbitration because there is just one thing that litigation has not will take a long time to catch up with, and that's the New York Convention. And parties are concerned about enforceability, and you cannot beat the New York Convention in terms of the range of enforceability of your award. So, but the solution there, of course, is the choice of court convention, and we need more people to come on board that one. And on this point of preferences, I go back to the survey that I mentioned just now by the International Dispute Resolution Academy of Singapore. I think it's very good for you to read the report, because the questions asked include the reasons for the respondents' preference for one mode to the other. And they're sort of categorized into different kinds of reasons, and you can see the responses and why they prefer this, why they prefer that. And any jurisdiction that is serious about building up dispute resolution services should pay attention to what the market is asking for. Thank you.
Ron, you are muted.
Shala and Hugh, do either of you want to add anything on arbitration versus litigation with the new international commercial courts? Hugh?
For me, that I just want to add one thing is the comparison between litigation and arbitration. And one of the most concerns, as all the panelists highlighted, is the enforcement of the awards. So the Dubai International Financial Center, I want to highlight that they have the mechanism to convert the judgment to the arbitral awards, which could be easier for the parties to enforce their judgments. Thank you.
Yeah. My understanding is there's been some concern about that as to whether it really then is an arbitration award under the New York Convention and can circulate under the New York Convention. I guess I'd like to take it one step further here, because it seems to me we have three options instead of just arbitration and litigation. We have arbitration, we have the new hybrid courts, the international commercial courts, and we have traditional courts. And there are traditional courts that have been magnet courts. Certainly London has played that role. And according to the CEDRA survey, still plays a significant role in that. The Southern District of New York plays some of that role, I think. And so 3 different choices. In those choices, I guess there's an issue that I found often never gets discussed, and is in part because maybe we don't teach it in the law schools, but that's filing fees. And the surprise that some clients have when they're told, you told us to choose arbitration, we chose arbitration, you put it in the contract, now we have to go and the filing fee is several $100,000. In US courts, filing fees are a few $100s. In many parts of the world, judicial filing fees are like arbitration filing fees. They're a percentage of the amount in controversy. Can you comment on that as a matter in the new hybrid courts? Do they come closer to arbitration, or do they come closer to the Southern District of New York that charges you $500 or $600 to file any size case?
Ron, may I say something quite useless? I'm one of those people that never learned about filing fees in law school, and frankly, I never paid very much attention to it as an academic. As far as the SICC is concerned, I can't say anything. I don't know about the details of the filing fees. All I can say is that during the time when the discussions were ongoing about whether or not to set up the SICC in Singapore, one of the issues that was raised was that arbitration was becoming too costly, and it's time to bring litigation back as a viable option for the parties in dispute. So this was a matter that was very much in the minds of the people who behind the design of the SICC. So I can't see how they could make it more expensive than arbitration.
Okay.
That's all I say.
Maybe I'm correct that we don't think much about filing fees, and so it doesn't come up much. But
Ron, sorry if I can add on that. I think, yeah, it's all correct. I think there is a colleague who was done a survey of the fees for each of these new hybrid courts, and the findings are that it's basically very low. So it's much lower than arbitration, and it's more or less at the same level than domestic courts, if not lower, because these hybrid courts are very often sponsored, subsidized by the state of Qatar, UAE, or China that want to boost, develop a new activity.
Okay, well, we have reached the scheduled time for conclusion. Actually, it's gone over a few minutes here, but I want to once again thank our panelists for excellent presentations, a wonderful review of dispute resolution in the region. A couple of administrative matters, just to remind some of our participants, if you are going to claim Pennsylvania continuing legal education credit, you will receive an email on Monday on that, to which you respond for that. And second, we are recording the sessions. They will be on YouTube. If you can't find them, otherwise send an email to cile@pitt.edu and we'll send you the link on that. So we will take a break now and resume at 9:40 with our second keynote address by Anthony Diprin.
Good morning and good afternoon. My name is James Cook. I'm the Associate Director of the Asian Studies Center at the University of Pittsburgh. And it is my great pleasure this morning to introduce our second keynote speaker, Mr. Anthony Diprin, who will be joining us, I assume, from Hong Kong. And his talk will build upon the first keynote speaker, Professor Susan Finder from Peking University's Transnational School of Law. The Asian Studies Center at the University of Pittsburgh is a national resource center supported by the U.S. Department of Education. And we would like to acknowledge the support of the NRC funding for today's event. Now, getting back to more important matters, our speaker today is a Hong Kong-based writer, lawyer, and photographer. He is the author of 2 books on Hong Kong, including his most recent book, City on Fire, The Fight for Hong Kong, which I had the pleasure of reading over the winter break, and I found it extremely engaging. And if you're interested in learning more about the events of the Hong Kong protests, I highly recommend picking up that book. His writing has appeared in The Atlantic, The Guardian, New Statesman, Courts and Foreign Policy, among others. And he is a regular commentator on television and radio, including the BBC, CNN, CNBC, and other media outlets. He's also qualified as a lawyer in Hong Kong, England, and Australia. And over his 20-year legal career, he advised many of China's leading companies on raising capital and doing business internationally on transactions that were transformational for China's business and economic landscape. A fluent Mandarin speaker, he has resided between Hong Kong and Beijing for over 20 years. Thank you again for joining us this morning or this afternoon. Please.
Thank you, James, for that very kind introduction, and thank you to the University of Pittsburgh for the invitation to speak to you all this morning. It's a great pleasure to be with you all here from Hong Kong. So I will be speaking about lawfare and the shrinking space for civil society in Hong Kong. It's actually a great pleasure and a privilege to be following on from Susan Finder, who is actually a former colleague of mine and a friend going back some 20 years. We worked together here in Hong Kong when I first arrived here. So it's really a pleasure to be sharing the billing with Susan. I'll speak for around 45 minutes to an hour or so and leave some time for questions at the end. So on to the topic at hand, lawfare and the shrinking space for civil society in Hong Kong. To understand that and to understand how that has changed in the past 12 months in Hong Kong, it's going to be necessary for me to begin first with some background of the national security law, a legal development that some of you may have heard of and be familiar with here in Hong Kong. The full text of the law of the People's Republic of China on safeguarding national security and the Hong Kong Special Administrative Region was revealed to the Hong Kong people at the same time as it came into force, at 10 minutes before midnight on the 30th of June, 1 hour before the 23rd anniversary of the handover of Hong Kong from Britain to China. It was notable in that it was a law that was imposed upon Hong Kong by Beijing. This was not legislated and passed by Hong Kong's own legislature, the Legislative Council. It was legislated and passed by the National People's Congress, the national legislature for the People's Republic of China based in Beijing, who, strictly speaking, under the one country, two systems formula under which Hong Kong is governed and has been governed since its return to China, would not ordinarily be the legislative body for Hong Kong. So this was in itself an anomaly. And the fact that Beijing felt the need to step in over the heads of Hong Kong's legislature and formulate this law, formulate it in secret, and then impose it upon Hong Kong was already something quite shocking to the people of Hong Kong, and indeed, I think it's fair to say shocking to much of the rest of the world, given how governments around the world responded to this, including the United States government, who responded with various sanctions and other punitive measures in response to this. But really, at the moment that the national security law was unveiled, Hong Kong as we knew it, and in particular the space for civil society in Hong Kong, permanently changed. I came to that realization the following morning. On the 1st of July, every year in Hong Kong, we have a large protest march, really protesting a variety of pro-democracy causes and all manner of civil society causes. Along the route of a typical 1st of July protest march, you will see stalls and people advocating everything from animal rights, elderly rights, housing justice, media freedom, LGBTQ rights, really every manner of cause and every manner of civil society group will gather on these 1st of July marches. But of course, in recent years, and given the protests, the pro-democracy protests of 2019, this year was going to be one very much focused on reviving perhaps the protest movement of 2019. And so as I was following the online coverage of that protest that morning, it was still a little early for me to get down to the streets myself, an image emerged of a new purple warning banner that the Hong Kong police were holding up and displaying to the crowds that were gathering at the protest that morning. And the warning banner read, "You are displaying flags or banners, chanting slogans, or conducting yourselves with an intent such as secession or subversion, which may constitute offences under the HKSAR national security law. You may be arrested and prosecuted." My first reaction was that I wasn't even sure if this was real or whether it was a practical joke. I mean, the idea that things like displaying flags and chanting slogans might suddenly be a criminal offence in Hong Kong almost seemed laughable. I mean, we all knew that there was this new law, but surely it didn't go that far. But as it turned out, the banner was no joke, and the police quickly followed through on their threat. The first person arrested under the national security law on that day was a man who was found to be carrying in his possession, in his bag, a flag bearing the slogan "Hong Kong Independence." And further arrests were made that day of some young women who were handing out or displaying stickers with what the police said were now illegal slogans, including "Reclaim Hong Kong," "Hong Kong Independence," and perhaps most strikingly, just the simple word "conscience." And that same day, a young man flying a flag from the back of his motorcycle bearing the slogan "Reclaim Hong Kong, Revolution of Our Times," one of the key slogans from the 2019 protest movement, inadvertently crashed his motorcycle into a line of police officers blocking the road. And he was arrested and charged under the new national security law with secession and terrorism offences. The national security law created 4 new criminal offences: secession, subversion, terrorism, and collusion with foreign forces. The offences are all vaguely drafted and broad in scope, and all carry penalties of up to life imprisonment. And in addition, the law covers anyone aiding, abetting, or inciting any of the above offences. The terrorism offence takes what are ordinary criminal acts, things like vandalism, criminal damage, arson, assault, manslaughter, and murder, all of which were, of course, reasonably and adequately addressed by Hong Kong's existing laws, and then defines them as terrorism if the perpetrators have any kind of political agenda or motivation. The law, as it's been drafted, appears to have been specifically crafted to be directed at many of the actions taken by protesters during the 2019 protests and other protest movements in Hong Kong stretching back into previous years, almost as if those protests were used as a checklist. Things that protesters did in 2019, such as vandalizing MTR stations, blocking the Cross Harbour Tunnel that links Hong Kong Island to the mainland, cutting traffic lights, throwing petrol bombs, all of those ordinary criminal acts now constitute acts of terrorism if they're conducted, for example, in the course of a political protest. Other acts of protest that attack or damage government premises or facilities that might otherwise, to use the words of the law, interfere with, disrupt, or undermine the operations of the government now constitute the crime of subverting state power. And so this would include acts such as occupying roads and blockading government buildings, as protesters did during the protests of 2019 and the umbrella movement protests here in 2014. It would also capture the filibustering and protest tactics that Hong Kong's pro-democracy legislators engaged in within Hong Kong's legislature. And it may even cover strike actions by pro-democracy labor unions, such as a notable strike last year in the early stages of the COVID epidemic, when hospital authority workers went on strike to try to force the government to close the border with mainland China in the very early stages to try and prevent the disease spreading from mainland China into Hong Kong. The offence of collusion with foreign forces covers anyone conspiring with a foreign country, organisation or individual to, among other things, disrupt the formulation or implementation of laws, call for sanctions, or simply provoke hatred among Hong Kong people towards the local or central governments. With the principal offences thus defined, the law then goes on to criminalise any act that aids, abets or incites others to commit those offences. So chanting protest slogans, such as the very popular protest slogan, "Reclaim Hong Kong, Revolution of Our Times," police say is now constitutes inciting secession and is therefore a criminal act. During the protests of 2019, there was a significant support shown to the protesters by ordinary middle-class Hong Kongers, and they would engage in various acts of support towards the protesters, such as donating money or equipment to help the cause, sheltering them from police, offering to drive them home from protests after the protests concluded, in particular after the government had shut down the transportation network, or even simply providing them with information. Now, anyone doing any of those acts in connection with a protest, which the authorities deemed to have been an act of terrorism or an act of subversion, now risk committing the crime of aiding and abetting terrorism or subversion. And so this really strikes at the heart of the cooperative spirit that helped the protest movement in 2019 to gain such traction. And it really has very deep roots across civil society in Hong Kong. And so the national security law really appeared to have been specifically crafted and targeted to criminalize dissent and really to put an end to political protest in Hong Kong once and for all. Among some of the many other surprises contained in the law was its extraterritorial reach. The national security law applies to any breach of its provisions by anyone, anywhere in the world. And this has prompted concern amongst overseas activists and indeed scholars and many academics as well, whose work may be considered to be critical of the Communist Party or Beijing in some way. But not only is it no longer going to be safe for them to set foot in Hong Kong, but indeed that the authorities here might use the extraterritorial aspects of the law to issue international arrest warrants for their arrest. And indeed, it's been rumored that there are already arrest warrants issued by the authorities in Hong Kong for several Hong Kong activists and dissidents who have sought asylum in countries overseas. But more than just creating these 4 new criminal offences, the national security law introduced structural and institutional changes in Hong Kong that were both deep and fundamental. The law established a new Hong Kong government agency, the Committee for Safeguarding National Security, which comprises the chief executive, who's the head of the Hong Kong government, key ministers, and representatives from the various uniformed services, such as the police, immigration, and customs and excise. This committee operates in secret, and its decisions are not subject to judicial review. It's now effectively become the single most powerful agency in the Hong Kong government. Beijing is empowered under the new law to nominate a national security advisor to that committee, which makes the first time that a Beijing-appointed commissar is inserted directly into the ranks of a Hong Kong government agency. And the head of the Central Government Liaison Office, Beijing's key representative office here in Hong Kong, Mr. Luo Huining, has been appointed the inaugural National Security Advisor, which some have observed effectively makes him the party secretary for Hong Kong. And with the national security law, that parallel party state governance structure that exists throughout the rest of China has now also been implemented in Hong Kong. The law made other deep interventions into branches of the Hong Kong government, including creating a new Special Prosecutor's Office for National Security Offences in the Department of Justice, a new Department for National Security in the Hong Kong Police Force, and the law also effectively sets up a parallel judiciary. The law requires that national security cases under that law can only be heard by judges drawn from a panel hand-selected by the chief executive, an arrangement that clearly puts a hole in Hong Kong's long tradition of judicial independence and the separation of powers, which are fundamental to the common law system that is the legal system that is adopted in Hong Kong. Indeed, separation of powers in itself has been a matter of some debate and controversy in Hong Kong. Many in Hong Kong, including those in the legal profession and even the judiciary, had assumed that Hong Kong did have a separation of powers system consistent with the common law. Yet Beijing and the Hong Kong government have recently announced that in fact that's not the case, and Hong Kong has a what they call an executive-led system where all the branches of government should be subordinate to the executive, including apparently the judiciary. This is just one of a number of ways that the national security law has undermined Hong Kong's rule of law. The national security law removed the power of final adjudication from Hong Kong's courts. Certain national security cases that are serious in nature can be removed from Hong Kong and tried in mainland courts. And interestingly, this has effectively introduced the very extradition arrangements that had so exercised the population here in 2019 and was the spark that began the protests here in 2019 that turned into that months-long protest movement. So that extradition has now been introduced by the back door through the national security law. The power to interpret the national security law is also taken out of the hands of Hong Kong's highest court, the Court of Final Appeal, and has now been vested in the National People's Congress, the legislature in Beijing. And finally, the national security law is all-powerful. In the case of any discrepancies between it and any other Hong Kong law, including Hong Kong's constitution, the basic law, and including things like the Bill of Rights Ordinance, the national security law prevails. And that means that the national security law cannot be challenged on constitutional grounds in Hong Kong's courts as any other piece of legislation might be in Hong Kong. And perhaps most alarmingly, most menacingly, the law empowers mainland national security agencies to establish a formal presence in Hong Kong through a new Office for Safeguarding National Security of the Central People's Government in the Hong Kong Special Administrative Region. This has effectively opened the door for PRC Ministry of State Security agents, the secret police in China, to operate legally in Hong Kong for the first time. They have set up commandeered a luxury hotel building in Causeway Bay for their first office here. And interestingly, that building is directly adjacent to Victoria Park, which is the traditional starting point for all protest marches in Hong Kong in recent years. So it's a very pointed positioning of their Hong Kong headquarters. The national security law ushered into Hong Kong a mainland-style strike-hard campaign, the term used in the mainland for a law and order crackdown or a law and order campaign. This campaign and its parade of arrests and trials is continuing and is continuing as we speak and is likely to continue for many months and even years to come. The aim, it appears, is for unacceptable groups and individuals to be excluded from government, from the education system, from the media, and from civil society at large. Hong Kong's previously freewheeling environment for freedom of expression has come to a sudden and crashing halt. In this new Hong Kong, acts of peaceful protest and acts of pure political speech, chanting slogans, waving banners, singing songs, posting on social media, all of these acts have been criminalized in certain contexts. A very stark and visible example of this sudden change to the environment have been in what are called yellow circle cafes. Yellow circle is a term that Hong Kongers use, yellow being the color that symbolizes the protest movement. Yellow circle businesses, cafes and restaurants are pro-democracy or sort of pro-protester business establishments. And many of these yellow circle cafes would have protest artwork, posters and banners displayed on their premises, and often have something called a Lenin wall. A Lenin wall is where multicolored post-it notes are pasted to a wall where people will leave messages of support for the protest movement, messages of sort of defiance against the government, pro-democracy messages, and so on. And I'm afraid I don't have a PowerPoint presentation, but I can show you an image of a Lenin wall. So that's an example of a Lenin wall right there. So you see the post-it notes with the various messages of pro-protest messages. In the hours before the national security law came into force, all of these pro-democracy cafes and restaurants began tearing down all their protester artwork and tearing down and scrubbing clean their linen walls. And any that hadn't, in the days following the implementation of the law, received a visit from police, and police told them that they should be tearing down their linen walls to avoid being in breach of the law. And so there's a very clear scar visible on the surfaces of the city, where these once colorful places of artwork and displays of messages of support and so on have been torn down, leaving often blank walls in their place. Sometimes more ingeniously, leaving blank pieces of paper in their place, with the blank paper standing in place for the words that can no longer be spoken. And in some ways, that's perhaps an even more powerful message. But the national security law has been felt across many different aspects of civil society in Hong Kong, and already begun to constrain the space for civil society in Hong Kong. On university campuses, the student unions, who have been key participants in Hong Kong civil society for decades, and were very active in organizing in the 2019 protests, and also very vocal in their opposition to the national security law. They have been targeted by the authorities. The People's Daily, the official Communist Party newspaper in China, called the Student Union of the University of Hong Kong, quote, "a malignant tumor that needs to be removed," unquote. And shortly after that, both the University of Hong Kong and Chinese University, one of the other major public universities here, announced that they would stop providing funding to the student unions, stop providing administrative support and venues for their activities, in practice, effectively severing all ties with the student unions and forcing them to shut down, or making their continued operation impossible on campuses. Other civil society groups have also been targeted in the ongoing crackdown. In particular, two very prominent civil society groups associated with the protest movements and the pro-democracy cause. One is called the Hong Kong Alliance in Support of the Patriotic Democratic Movements in China. This was a civil society group that formed after the Tiananmen protests of 1989, and every year since then has organized a very large vigil, candlelit protest gathering in Hong Kong, in Victoria Park, on the 4th of June every year to mark the date of the Tiananmen Square massacre. The other civil society group is called the Civil Human Rights Front. They are an umbrella group of several dozen civil society groups who organized that annual 1st of July protest march that I mentioned earlier, and were also instrumental in organizing many of the protest marches in the 2019 protest movement. Both of those organizations have been accused in the Beijing press of breaching the national security law. There has been some suggestions by government proxies and pro-Beijing spokespeople that the alliance, the vigil organizers, may now be an illegal organization, a subversive organization, and may be shut down and outlawed. And Hong Kong police recently announced an investigation into the other group, the Civil Human Rights Front, and that investigation appears to be moving towards banning that group and imposing criminal penalties as well as potentially national security charges on its key figures. And so it seems very likely that that group is going to be shut down quite soon. For other civil society groups, the police have very actively targeted any kind of crowdfunding or fundraising efforts. Something that's been very notable has been the willingness of Hong Kong people to throw their weight or throw their support behind various civil society groups, in particular pro-democracy or protest-oriented groups, by donating significant amounts of money to them. And when these organizations ask for funding, they often receive significant amounts of donations in the hundreds of thousands of US dollars in a matter of a day or two, as people are very willing to donate to these causes. So police have been targeting for scrutiny any kind of crowdfunding activity. This has often resulted in the bank accounts of these organizations being frozen and anyone involved being accused of money laundering, and the money laundering laws being used to target these sorts of civil society fundraising exercises. Many other civil society groups, including political parties and other groups, voluntarily dissolved and wound up their activities either shortly before or immediately after the national security law came into force. Some of those included Demosisto, which was the youth-led pro-democracy political party founded by Joshua Wong, a very famous dissident that no doubt many of you have heard of. They dissolved immediately and no longer exist. And another group, Network Diplo, which was founded by a Hong Kong political science academic with the aim of essentially engaging in research and engaging advocacy on various political issues. They are two of the many other civil society groups that have ceased their operations and closed down, considering that the risk in the new environment is too great for them to continue. The arts sector also found that they were not immune to criticism, as loyalists seeking to curry favor with Beijing turned their attention to any kind of art or cultural activity that carried any whiff of dissent. It was surprising to see the major government-funded art museum M+, which is a new world-class facility the size of the Tate Modern, currently being built on the Kowloon waterfront and due to open later this year, to find it in the firing line of pro-Beijing politicians. They allege that certain works that are known to be held in the M+ collection by dissident artists such as Ai Weiwei were in breach of the national security law and were spreading hatred against the country. And just again in my alternative to a PowerPoint presentation, but this is the image that drew their ire. It's a series by Ai Weiwei called Studies in Perspective, where he has he presents his middle finger to a number of prominent national landmarks, including, of course, in the US and in France. And here, of course, a very prominent and sensitive national landmark in Beijing. That's Tiananmen Gate with Chairman Mao's portrait hanging on the front. And it was alleged by the pro-Beijing politicians in Hong Kong that this was a subversive artwork which M+ should commit to not publicly displaying, even though it forms a part of their permanent collection. Another pro-Beijing politician argued that public screenings of documentary films that depicted events during the 2019 protest movement were acts of inciting terrorism, which quickly led to those screenings being withdrawn. For businesses, Hong Kong may have once been regarded as being a politics-free zone, and that certainly is no longer the case. Companies, both local and international, were called upon to make statements in support of the national security law after it had been announced, but before they'd even seen it. Most companies fell quickly into line, in particular Hong Kong and mainland Chinese companies. When the HSBC Bank had failed to do so, it was subject to what you could regard as a social media shakedown by former chief executive, former head of the Hong Kong government, CY Leung, who has a very active presence on Facebook, where he continues to appeal to his fan base of pro-Beijing followers. And CY Leung wrote on his Facebook page, "It's been over a week and HSBC still hasn't expressed a position on the national security law. They should know which side their bread is buttered on." And following that attack, HSBC duly came out and expressed their support for the national security law a few days later. But these kinds of demands on both local and international businesses, and also on business leaders personally, to take a public position, or to 表个态, as they would say in Chinese, on political issues, are now really a feature of the Hong Kong business landscape. And I think we should expect that will only accelerate, and that these sorts of displays of loyalty are going to be the price for market access. And indeed, we're seeing this in the mainland as well, with the controversy around Xinjiang Cotton and a number of international businesses, including H&M and others, being caught between needing to play to their domestic market, domestic political concerns or international political concerns, and demands from Chinese consumers and from the Chinese government that they should take what's considered the pro-China view. And Hong Kong is no longer going to be immune to that. I think multinationals may increasingly find themselves in an uncomfortable position when the demands from the Hong Kong government or the mainland government here in Hong Kong conflict with the international or their own domestic political considerations at home. Moving on to the media, there has already been a deteriorating climate for media freedom in Hong Kong, and I think the national security law has only added to those uncertainties. Excuse me. Many foreign media outlets have begun to reassess their position in Hong Kong. The New York Times notably announced that they would be moving their entire Asia digital operations, around a third of their current Hong Kong-based staff, to Seoul due to uncertainties around the national security law. And many media outlets have found visa applications or visa renewals for foreign journalists to be delayed or rejected by the authorities without explanation, something that the Foreign Correspondents Club here has called highly unusual, as foreign media come under increasing scrutiny. Of course, the local Hong Kong media have also been under scrutiny. The public broadcaster here, Radio Television Hong Kong, or RTHK, has come under significant political pressure. The broadcaster has been widely praised and considered the most trustworthy news outlet in Hong Kong for its objective reporting. But I think, not unlike many other public broadcasters around the world, its critical coverage has been a source of government ire. And in the same way that you often hear politicians in other places that have significant public broadcasters, like the BBC in the UK, or the CBC in Canada, or the ABC in Australia, where governments get unhappy when the public broadcaster criticizes them or their policies, the same thing has happened in Hong Kong, but with much more dire results. After a government review of RTHK earlier this year, which concluded the broadcaster had editorial deficiencies, the government appointed a new director of broadcasting, a career civil servant with a long track record of loyalty to the government, but no experience in media or broadcasting. Upon his assuming the role, he's quickly moved to suspend programs and axe episodes of current affairs programs covering contentious political issues, such as electoral reform, university student unions, and ironically, press freedom. Bao Choi, a producer of an award-winning documentary for RTHK, in fact, was recently prosecuted by the authorities for what they said was inappropriate access to a traffic database, which she had recourse to look up in the course of her investigative reporting for a politically sensitive topic. And this led to really significant concern that she was being prosecuted for engaging in investigative journalism, investigative reporting that the government did not like. And she was convicted and fined for that by the courts. Excuse me one moment. Reflecting this rapid decline in press freedom, Reporters Without Borders ranked Hong Kong 80th out of 180 countries in its World Press Freedom Index from 2020 for 2021. This is a dizzying fall from grace. Hong Kong had ranked 18th in the first index published in 2002. At the time, was the highest ranked region in Asia, and now it has fallen to 80th. And I think it's likely that the pressure on the free press here will continue. Hong Kong police, supported by the pro-Beijing media and politicians, pushing for new restrictions on the media here, including a licensing scheme for journalists and a fake news law inspired by similar laws recently introduced in Singapore, which would give the authorities powerful new tools to attack reporting that dared to deviate from the official narrative. These reforms will inevitably prevent an independent media from properly functioning to hold the authorities to account. Indeed, the first major operation under the national security law was also simultaneously an attack on the media. In August last year, hundreds of uniformed police raided the offices of Next Media Group, who are publishers of the pro-democracy newspaper, the Apple Daily. And they arrested Jimmy Lai, the outspoken chairman of that group, someone who'd been very prominent in supporting the protests, in funding for them, and in liaising overseas, meeting with politicians around the world, in particular very prominently with people such as Mike Pompeo and others in the US, helping to advocate for Hong Kong's pro-democracy movement. And so he and several of his executives were arrested and charged with offences under the national security law, as well as fraud charges. Lai was hauled to court in chains, denied bail and remanded in custody after Hong Kong's highest court confirmed that the national security law contains a presumption against bail. And just last week, the authorities announced that they have put a freeze on some $70 million worth of Jimmy Lai's assets here in Hong Kong, including his majority stake, his shares in Next Digital, the publisher of the Apple Daily newspaper. And I think it seems very likely that that asset freeze, which they say is necessary to further their investigation and enforcement of the national security crimes that Lai is charged with, will lead to the Apple Daily eventually, I think, being forced to cease publication. More arrests under the national security law have followed. Teenagers have been dragged from their beds in the middle of the night and arrested for their posts on social media that police said had incited secession. A district councillor who held up a placard with the Reclaim Hong Kong slogan at a protest was arrested. And students who carried banners with pro-independence slogans during a graduation day protest at the Chinese university. In addition to arrests under the national security law, the prosecution of the thousands of arrests made during the 2019 protests, indeed some 10,000 people were arrested in the course of those protests, have begun winding their way through the courts. These prosecutions and other actions against opposition politicians, protesters, and dissidents have all shown the Hong Kong authorities engaging in what I have referred to as lawfare. Lawfare is the use of the legal system by the Hong Kong government as a tool to achieve its political objectives and as a tool to target dissent and opposition figures. Lawfare is politically astute in that by relying on the legal system, it enables the authorities to appeal to the need to uphold Hong Kong's rule of law, something that is both universally recognized here in Hong Kong as a core value, and also recognized internationally as something that's unimpeachable and indeed something that's desirable for Hong Kong's status as an international financial center. Yet at the same time as they appeal to the rule of law, they use that same legal system to target the actions of the dissenting politicians and activists. This lawfare campaign has been pursued most aggressively in the prosecutions of protesters and protest-related arrests. Those prosecutions are made under something called the Public Order Ordinance, one of the main weapons in lawfare, a blunt force tool really wielded heavily by the state here. This ordinance was introduced in 1967, a time when there were other very violent protests happening in Hong Kong at the time. The Cultural Revolution was raging in the mainland, and pro-Beijing Maoists began protesting, rioting, and engaging in a terrorist bombing campaign on the streets of Hong Kong. Events that were significantly more violent than the events of 2019. In the course of those events, the British colonial authorities passed this ordinance, the Public Order Ordinance, and it still remains largely unchanged today since the time of its enactment, and is still being used to police dissent and public protest today. And that ordinance provides that any public gathering or march to which the police have objected under a notice of no objection mechanism is an unauthorized assembly. And any assembly of 3 or more people conducting themselves in a disorderly, intimidating, insulting, or provocative manner is an unlawful assembly. Taking part in an unauthorized or an unlawful assembly is a crime punishable by up to 5 years jail. And when an unlawful assembly results in a breach of the peace, it becomes a riot, and riot is subject to a jail term of up to 10 years. So among some of the many prosecutions and convictions that have occurred in the course of this Lawfare campaign, very notable activists, Joshua Wong, Agnes Chow, and their fellow members of the Demosisto political party were sentenced to around a year's jail for their roles in inciting a protest during the 2019 protest movement. A 27-year-old barista was sentenced to 4.5 years jail for arson and riot after she threw some cardboard and debris onto a fire on a road during a protest in September 2019. A 20-year-old university student was jailed for 8 months for being caught in possession of a laser pointer and a spray paint bottle. And another youth was sentenced to 3 months jail for possessing a laser pointer that he pointed at police for 40 seconds during a November 2019 protest. 21 people were charged with perverting the course of justice for helping protesters to escape from the campus of the Polytechnic University when it was under siege from police during a very dramatic and violent protest in late 2019. And a registered social worker who was at the front lines of a protest asking police to let protesters leave safely was convicted of obstructing police. In April this year, the district court found 7 of the most senior pro-democracy figureheads and legislators here in Hong Kong guilty of organizing and participating in an unlawful assembly in connection with a protest in August 2019. The accused in that trial included the father of Hong Kong democracy, Martin Lee, the founder of the Democratic Party, another former Democratic Party chair, Mr. Albert Lee, prominent protest figureheads Lee Chuk Yen and a character called Longhair Leung, our senior barrister and former legislator Margaret Ng, and Jimmy Lai of the Apple Daily, among others. Lee, Ho, and Ng received suspended sentences, and all of the others were jailed for between 6 and 9 months. And these were really among the most senior and the most respected of the pro-democracy movement here in Hong Kong, and all of them fell foul of the charges under that public order ordinance. They are also, many of them are also facing further charges and will face trial again in relation to other protests that occurred in the course of 2019. In 2019, there were protests happening almost every weekend, many of them attended by leading pro-democracy activists and politicians, and therefore the police have a backlog of charges that they're going to continue to charge and prosecute these various people with. So many of those same people are actually back in court next week on similar charges for a different protest on a different day. Throughout these prosecutions, a pattern has emerged. The prosecutorial discretion, the decision of whether to charge someone, what charges should be pursued, and what sentences should be sought, is usually a pragmatic one. It's made on the basis of policy, in the face of the reality of limited budgets, limited court resources, and limited court capacity. And this was a point that the chairman of the Hong Kong Bar Association, or rather the former chair, Philip Dykes, SC, emphasized in a speech he gave at the opening of the legal year in January last year, when he told his audience, which included, of course, many of the most senior members of the Hong Kong judiciary, representatives of the government and the legal profession, that, and I quote, "A decision to prosecute is not made just because the police have enough evidence to go to court and secure a conviction. Public interest plays a part in the decision-making process too, so that individuals or some classes of cases should not end up in court, even though there might be a strong case against them," end quote. Yet, in the case of all of these protester and activist cases, it seems that prosecutorial discretion is exercised almost uniformly against the dissenters. The long, drawn-out nature of the prosecution process and the timetables also appears calculated to maintain pressure on the activist community. jail, bankruptcy, ruined career prospects, the Hong Kong government seems to be seeking to make the cost of dissent intolerably high through its prosecution process. Now, they would argue that they are simply upholding the rule of law, but it seems to me that this is categorically not rule of law. When the authorities identify the people they want to target and then trawl around for charges to pin on them, that is not the rule of law. The largest and most dramatic operation under the national security law and the Lawfare campaign came in January of this year, when the government arrested 55 people in the largest mass arrests yet under the national security law. These people were arrested for conducting a primary election last year. The pro-democracy camp, to prepare for elections that were supposed to have been held last year, decided to conduct a primary to coordinate among themselves who would contest the various seats to try and maximize their chances of winning. And one of their proposed strategies was that if they were able to win a majority in the legislature, they would try to force the government to accede to the protest demands, and if the government refused, they would, using entirely legal processes set out in the Constitution, veto the budget and seek to force the government to resign. The government said that this primary election itself was an act of subversion. And so all of the candidates who ran in the primary, so effectively the entire political opposition, the entire slate of pro-democracy candidates who were going to contest the election, were all arrested in one fell swoop. Others arrested included a prominent academic, Benny Tai, who had formulated this plan, people who'd organized the primary, including an American human rights lawyer in his 70s. The authorities said that Tai's plan and this primary election were all part of an overarching vicious plot with the aim of, they said, paralyzing the government. And of those arrested, 47 were formally charged in March with subversion and remanded in custody as the government sought to oppose their bail application, citing the national security law's presumption against bail. The bail hearing really was a grotesque spectacle, a marathon, week-long hearing, all 47 defendants crammed into the one court with their lawyers, the one courtroom. The hearings dragged on late into the night, past midnight on some days throughout the week. The defendants unable to properly shower, change clothes, sleep. Some of them passed out from exhaustion and were taken to the hospital. Ultimately, 11 of the 47 were granted bail. The remaining 36, including many of these very senior politicians, sitting in jail, awaiting trial while the prosecution continue to carry out their investigations, which they say will last for several more months. Prosecutors were also handed a potent new weapon in their lawfare arsenal with a March court ruling that the theory of joint enterprise could be used to charge anyone who encouraged or assisted the commission of a public order offence, including rioting. Now, this ruling opens the path for the thousands of people arrested in the vicinity of protests in the course of 2019 to be convicted with the serious crime of rioting, with potential jail sentence of up to 10 years, with very minimal evidence required. Even those people who were not actually present at the scene might face criminal liability under this new ruling. So examples that the court gave of the kind of activities that might result in criminal liability included funding or providing materials for protesters, providing backup support, acting as a lookout, driving transportation, or even merely encouraging or promoting the unlawful assembly or riot by spreading messages on social media or through chat applications. So this really covers the actions of many of those moderate protest supporters who were behind the scenes in the course of the 2019 protests, but it also raises the spectre of criminal liability for pure political speech, such as social media postings. And indeed, the prosecution, in the course of arguing that case, actually tried to argue that even simply clicking like on a social media post might be sufficient to attract criminal liability, although it does seem that the court didn't go as far as accepting that particular argument. The ruling's quickly been adopted by the courts, and indeed, just a couple of weeks ago, 3 protesters were jailed for 4 years for rioting during a protest in 2019, just because they were present at the scene, even though there was no evidence that they were involved in the riot. And it seems likely that more convictions and imprisonments will follow. So the government's lawfare campaign continues. The criminal justice system pressed into service by the authorities to harass opposition activists and protesters, embroiling them in prosecutions even for relatively minor offences. A few examples of some of the more notable ones, the police revived a colonial era sedition law to charge an activist, Fastbeat Tam Takke, with the crime of uttering seditious words. The seditious slogans he allegedly chanted at a street stall in Mongkok included many of the protest slogans that were popular in 2019. And not only that, but Tam was charged with conspiring and aiding and abetting someone else to utter seditious words for the act of passing them the microphone so that they could also chant the slogans over his loudspeaker system. Another activist, Tony Chung, was sentenced to 4 months imprisonment for the crime of desecrating the national flag after he snatched a flag being wielded at him by a pro-government protester. Another former pro-democracy lawmaker, Ao Nok Hin, was given a 9-week prison term for assaulting a police officer by speaking over a loudhailer after the police officer complained that the loudhailer was too loud and hurt his ears. So many of these prosecutions have also relied on the criminalization of handling ordinary objects, everyday objects, with hundreds of protesters being arrested for possession of offensive weapons after police found them with things such as laser pointers and zip ties and other tools that were used in the course of protests. Laser pointers are very notable. Laser pointers were sort of adopted by protesters as a way of annoying and distracting police. On the front lines of the protest, they would point laser pointers at the police and shine them at them just to annoy them, frankly. So a protester was charged with offensive weapons charges merely for carrying 5 zip ties. Another woman was fined for carrying a bottle of paint during a day of protests. The court concluded that the fact she was carrying the paint without a paintbrush showed that she'd intended to use the paint to damage public property. The lesson therefore being, if you're going to travel with paint in Hong Kong, always ensure that you bring a brush with you at the same time. However, the past year has also been characterized by a constant stream of acquittals as an indecently large number of protest-related cases were revealed to have been built on flimsy prosecution evidence or tainted with accusations of police misconduct, including police giving false or unreliable testimony and tampering with evidence. Among several examples, prosecutors were forced to drop charges against a defendant charged with storming the Legislative Council building on 1st of July in 2019, after they admitted that the only evidence they had against the accused was one piece of paper bearing the suspect's fingerprint. 2 university students were acquitted of charges of obstructing roads during the campus sieges after police admitted that they could not positively identify the defendants, who'd simply been arrested on a nearby footbridge. In other cases, protesters have been acquitted of rioting when the only evidence that police had was their being dressed in protester attire near the site of the protest. However, after the recent joint enterprise ruling, it seems that in future cases, people who have been arrested in such circumstances probably will be found guilty of rioting and sent to jail, with only on the strength of the evidence that they were in protest attire and arrested in the vicinity of a protest. In some cases, video footage presented to the courts has directly contradicted the prosecution cases or the testimony of the police witnesses, and this has occasionally attracted damning criticism from magistrates and judges. One magistrate accused the police witnesses of, quote, telling lie after lie, unquote. No police have been charged with perjury as a result. The use of arrest as a means of crowd control during 2019 was common. And it was a tactic, I think, that the police used to quickly round up people and get them off the streets to try and restore order. However, to actually pursue prosecutions against all of those arrested is an unusual step. And really an extraordinary waste of police and prosecutor resources. There were, as I said, over 10,000 arrests in the course of 2019. If all of those cases were to work their way through the court system, it would take many, many years. And bear in mind that bringing these cases is not free of cost for the government. Pursuing any case has financial costs. It has costs in terms of time and court resources. and of course the opportunity cost of foregoing the ability to try other cases. And it's because of these costs, and of course also the pride in their own conviction record, that prosecutors are usually loath to pursue a case when they don't have a reasonable prospect of securing a conviction. And indeed, there's a potential argument that it is potentially an act of malpractice to do otherwise. However, in these protest prosecutions, the Hong Kong government has appeared to be determined to bring the cases to court regardless of the costs and regardless of the prospects of success. They've been encouraged in this by Beijing, who has often spoken, or whose spokespeople have often emphasized the need to uphold the rule of law and to bring wrongdoers to justice. And indeed, any protests or acquittals often provoke a furious response in the pro-Beijing press, and occasionally from government spokespeople and pro-Beijing politicians who criticize the judiciary, argue that the judiciary are treating protester defendants overly leniently. And this really culminated in a November speech last year by the Deputy Director of the State Council Hong Kong and Macau Affairs Office, the most senior department in the government in Beijing responsible for Hong Kong policy, Mr. Zhang Xiaoming. And in that speech, he said that Hong Kong's judiciary was in need of reform. And this has now become a recurring theme in the pro-Beijing media and among various other government proxies and spokespeople, that there is a need for the Hong Kong judiciary and the judicial processes to be in some way reformed. With Beijing's control over the executive and the legislative branches in Hong Kong near total, the judiciary remains as the only branch of government that continues to exercise effective checks and balances on unfettered executive power. And notwithstanding the government's attempts to carry out this campaign of lawfare that they've been involved in, Hong Kong's independent judiciary overall have, I think, performed admirably. They have held the line, continued to make judgments in accordance with the law, and generally with impartiality and neutrality, and have really behaved as really that last bastion, that last effective check and balance on executive power, and in the best interest of upholding the rule of law. But I'm afraid that given the tone coming from Beijing, their future prospects are looking increasingly dim. And as I've outlined in the course of my remarks, as are the prospects for Hong Kong's civil society in the future, and the prospects for even expressions of non-violent protest and non-violent dissent. Hong Kong has entered a new era where many of the assumptions that people who lived here operated under, I think no longer apply. And I think in the course of my comments today, I have helped to explain how that has changed over the course of the past 12 months. And I'm sorry that I can't give a more upbeat, conclusion, but it would be, I think this is sort of an assessment of where we are at the moment, and I encourage all of you to continue to pay attention to Hong Kong and to have an interest and to see how things develop here. So with that, I'll finish my prepared remarks and happy to take any questions.
Thank you, Anthony, for that very, very comprehensive overview of all the enormous changes that Hong Kong has been subjected to over the past really only 10 months when you think about this. It has not even reached 1 year since the national security law has been initiated in Hong Kong. And really the scope of and the breadth of the many aspects of Hong Kong's civil society that has been affected by the new national security law is really astounding, and at the same time a moment for all of us to pause and to consider what lies in the future for a place that many of the people who are participating in today's conference are obviously very, very interested in. Now, I want to encourage our audience to please enter questions into the Q&A function. We are starting to see a few. The first questions that we've received focus on, first of all, foreign governments and organizations, and then the second on academic freedom. The first asks, how do you see the roles of foreign governments and organizations such as AmCham, the American Chamber of Commerce in Hong Kong, from falling into this, they use the term abyss, without breaking the law, which states that colluding with a government can be subject to arrest, as you pointed out in the beginning of your presentation?
Yes, it's a very good question, and indeed, as the questioner points out, the law is crafted such that anyone who actively works with a foreign organization to interfere in governance in Hong Kong is potentially committing a crime. So it's difficult for foreign organizations and foreign governments to do anything, and certainly impossible for anyone in Hong Kong on the ground here to cooperate with them. I guess there's one thing that has been, I think, certainly noticed and appreciated by people on the ground here is those foreign countries that have been offering opportunities for Hong Kongers who wish to leave and wish to relocate. And the UK has notably done that by opening up a path to residency and citizenship for those Hong Kongers who have what are called British national overseas passports, people who were formerly colonial subjects in the pre-handover era. Other countries such as Canada and Australia have expressed that they are welcoming of Hong Kongers. I know there's some potential legislative action happening in the US around some form of relief or safe haven program for Hong Kongers as well. And those are things I think people on the ground here certainly very much welcome. In the sense that it provides them options if they feel that's necessary. From the point of view, I think, of foreign businesses and organizations such as AmCham, that through which those foreign businesses can express their concerns to the Hong Kong authorities, I think that's something that is constructive. And there was a very recent AmCham survey that came out last week that had some very notable responses in there as to the number of foreign residents in Hong Kong who were thinking about leaving, and concerns they had around the impact on the business environment here, which is something that the Hong Kong authorities are always very responsive to. I think that's helpful. But I think at the end of the day, perhaps the most important thing is just to continue to watch and pay attention and ensure that whatever happens here happens in the full light of day and sort of the scrutiny of the wider world, rather than happening in darkness, as it were.
So, Anthony, you mentioned that the national security laws are very, wide-ranging and sweeping, and in many ways, it criminalizes a large proportion of Hong Kong's, 7.5 million people who are living in the region. Do you have any idea or estimates of what percentage of people would be found as having violated that law over the past year?
Look, there were at the largest protest in 2019 had some 2 million people take part. So that's sort of, I guess, one rough indicator. I'm not saying that everyone who took part in that protest was breaking the law or would have been breaking the law had it come into force at the time. But it certainly shows that the cross-section or the size of the community that was sympathetic to the protest movement. I think it really was a very significant chunk of the population here. And indeed, in the local council elections we had at the end of 2019, the pro-democracy parties won some 60% of the vote. So you could argue that 60% of the voting population, at least, was sympathetic to the protests, and may have engaged in acts which, had the national security law been in force at the time, may well have been criminal. And one very small blessing that was contained within the national security law is that it's stated not to be retrospective in effect. So it only applies to acts happening after it came into force. And it has had such a chilling effect since coming into force that I think many people who had been very active in the course of 2019 and the protest movement then are now afraid to do so. And of course, any kind of protest activities have been constrained over the last year or so due to the COVID epidemic, and the various social distancing rules and things that have prevented people gathering in public. When we eventually come out of COVID and come back to a time when, at least from a public health point of view, people are free to gather in public and to engage in various kind of public activities, it'll be interesting to see to what extent people are willing to do so under the cloud of this new law. And I think that many people, or the chilling effect of the law will be such that many people will be reluctant to tempt fate, as it were, and to risk prosecution or to risk breaking that law.
Thank you very much. Another question we've had focuses on academic freedom. They wonder if you have heard or seen any concerns that academics are planning to leave Hong Kong because of the situation. They also comment that they have a friend who works in investment banking in Hong Kong, and she has been saying goodbye to at least one colleague each month since last June, many of them leaving Hong Kong and not just resigning.
Yeah, so on the point of academic freedom, there is certainly a great deal of concern among academics in Hong Kong, and in particular academics in particular fields such as in the law, in political science, and in various other potentially sensitive areas. But frankly, in this era, everything is sensitive. A great deal of concern as to what kind of content they can teach students, as to whether classroom discussions will be monitored, as to whether they're going to be free, there's sort of going to be a free environment for discussion in classrooms. Yes, certainly there is a great deal of concern, and unfortunately, from what I hear from people who work within those institutions, the institutions have been very unhelpful in terms of addressing those concerns. At various meetings that are held with faculty to sort of explain the institution's position under these new laws, invariably the message they get is essentially, be careful not to break the law. Of course we support academic freedom, and of course you shouldn't break the law, which is a very unhelpful sort of response to give to concerned people. So certainly I think it's inevitable that people will be trying to make a guess where the red line is, taking several steps back from that and sort of positioning their activities accordingly. And so I think inevitably this is going to lead to censorship of academia. And I don't use the word self-censorship advisedly. I think there's no such thing as self-censorship. In the end, it's all censorship. It's just indirect censorship. As to the phenomenon of people leaving, that's certainly been the case. I mean, really since at least since the beginning of this year, after the UK proposals became clear, one of the most common topics of discussion among people in Hong Kong is, are you staying or leaving? And that's whether among the expat community or the local community. And there are many that have already made plans to leave, others that are talking about it and haven't yet committed. I think many are taking a wait and see approach, but want to keep their options open. I think one of the big concerns is the education system and the impact that this new regime will have on the education system, and people who are concerned about the education of their children. So people with young children are looking to perhaps looking more carefully at whether they want to be somewhere else for their children to grow up in a different education environment as well. So I think that anecdote that the questioner raised of people experiencing sort of saying farewell to a colleague a month is a fairly typical experience. And indeed, I've heard other people observe that the fear and anxiety now is even greater than it was in the lead up to the 1997 handover, in terms of the last time that there was a significant exodus of people moving away from Hong Kong.
So since our conference here has been focusing on China's impact on commercial law, obviously Hong Kong has been viewed for decades as a gateway for investment and working in China, you yourself have been obviously involved in many has probably helped many of these companies set up bases within Hong Kong so that they can, for example, perhaps open a factory in Shenzhen or other parts of China. Do you think that the national security law will have a chilling effect on this kind of activity as well?
I think it very much depends on the nature of the business and the reason that the businesses have come to Hong Kong. For those businesses that come to Hong Kong primarily for the purposes of using it as a footstep into the mainland China market, and for whom it's an easier and more convenient place to sort of set up and do your banking and operate in a primarily English language environment, for example, but the actual substantive business is on the mainland. I think the new environment doesn't make much difference to them, with the assumption that in any event, it's not going to be at its sort of worst, if you want to use worst as a standard. It's not going to be any worse than the mainland. So as long as the other aspects, the sort of the convenience outweigh that, then Hong Kong, I think, is still an attractive place. However, for the people who were in Hong Kong precisely because it wasn't the mainland, and that's things like media organizations, international NGOs, tech organizations, organizations that had concerns around things like security, political sensitivity, IP, those sorts of things, they're certainly rethinking their plans. As I mentioned, the New York Times has already moved a chunk of its operations to Korea. I've heard and spoken to various investment managers involved in sort of hedge fund management who are concerned that there might be political sensitivities around the trading activities, and they've been talking about relocating to Singapore, among other places. And so certainly for those organizations that had seen Hong Kong as a safe haven, or who had relied upon the sort of the two systems part of Hong Kong, they will be rethinking their plans. I think Hong Kong is significantly less attractive for them.
Related to this is a question we've received another anonymously is, does the national security law prevent the flow of money or people in and out of Hong Kong?
So it not at the moment, but it could be used for that. Now, notably in terms of the flow of people, the Hong Kong government has just passed an amendment to its immigration ordinance, which gives the Director of Immigration the power effectively to impose exit bans. Now, the government has said that's not what they intend to use it for, and it's intended to deal with various sort of non-refoulement claims under refugee arrangements. But nevertheless, that's what the law says on the statute book now. And so people are very concerned that the government could constrain the flow of people both out of Hong Kong as well as into Hong Kong in future. In terms of capital flows, there's currently no indication that that would be affected, but certainly the asset freezing rule on Jimmy Lai shows that the national security law can be used to freeze the assets of people, even simply being investigated under the law. You don't have to have been convicted for those asset freeze orders to happen. And so there's certainly for anyone who is maybe potentially at risk under that law, their capital is at risk. But of course, anything more general than that would be really a death knell for Hong Kong as an international financial center. And I think that is something that Beijing is very keen to retain, because it's very helpful for Beijing's own purposes and for all the Chinese companies that use Hong Kong as a capital raising center. So I think anything of general application that's going to threaten Hong Kong's status as an international financial center, they are going to be much more careful about this out of their own self-interest.
Thank you. We have another more detailed question here. There has been a call for foreign judges to withdraw from the Court of Final Appeal. Please, they ask, what is your take on this?
Yeah, so just by way of background for those who aren't familiar, Hong Kong's highest court, the Court of Final Appeal, has a number of local judges here in Hong Kong. And it also has a unique arrangement where senior leading judges from other common law jurisdictions also sit on that court, are invited to sit on that court. So at the moment, in addition to the Hong Kong judges, we have judges from Australia, from the UK, and from Canada. And in the past, there have been also judges from New Zealand and South Africa sitting on that court. And that sort of served two purposes. The first has been to ensure the continuity of Hong Kong as part of the common law world, and that the rulings being made by the most senior appeals court in Hong Kong is in some way plugged into the wider common law world by having input from these very senior judges, sort of House of Lords members, retired High Court judges from Australia and Canada and the like, sitting on these cases and contributing to the decisions, and therefore ensuring that Hong Kong continues to be integrated and there's continuity with the rest of the common law world. But the other role they have, and the far more important one, is effectively as a guarantor of Hong Kong's rule of law and Hong Kong's judicial independence. These are some of the most senior and most respected judges in the common law world. Their willingness to sit on this court is intended to be a reassurance to Hong Kong, and I think in particular to the international business community, that Hong Kong's rule of law is healthy and its court system is working well and its judiciary is independent, because if it were otherwise, these people would be not willing to lend their personal reputations to such an institution. And so in the light of the national security law, there have been calls for some of these, from some quarters, for these foreign judges to step down. And indeed, one of them, Justice Spiegel, a former Australian High Court judge, did resign from the court, citing concerns around the national security law. In the UK, the president of the UK Supreme Court, Lord Reid, has said that the UK would be reviewing its position on that. And of course, the argument goes that these people the system is now such that it's no longer appropriate for them to lend their personal reputations to a system that has a law such as the national security law. On the other hand, the existing Court of Final Appeal judges here in Hong Kong, the local judges, including just the recently retired Geoffrey Ma, I think all of whom are themselves very fine jurists, have been very vocal in saying they would like the foreign judges to stay. And they think that the foreign judges continue to serve an important function as a guarantor of Hong Kong's judicial independence. And having seen sort of in person, met many of both the local permanent Court of Final Appeal judges and the foreign non-permanent judges, and seen the rapport that is between them, there is clearly a great deal of affection and respect between all of them. And I think there is a certain degree to which certainly the existing foreign judges are willing to stay to show their support to their colleagues, and to continue to sort of lend whatever assistance they can to uphold judicial independence in Hong Kong. And I think that while I appreciate the message that would be sent by them withdrawing, I think on balance it is still better for Hong Kong and better for Hong Kong's judicial independence for them to stay, at least in the current environment. Subject to what may happen in the future. But I should also note that they are not allowed to sit on national security cases. So that sort of, they are ring-fenced from those cases under the new law. So there's never a position where they would be, I guess, subject to potential professional embarrassment by having to sit on one of these cases. But then it also, of course, raises the question, is we're ending up in a sort of a bifurcated legal system with two different judiciaries, effectively.
Thank you. We have time for just one more question. I wanted, this may take us a little bit far afield, but folks are wondering, what is the feeling within Hong Kong about the new Biden administration in the United States? Do people expect changes from the way the Biden administration will approach the Hong Kong issue in comparison to the Trump administration? And also more importantly, what are the best and most effective ways to engage the Chinese government on the Hong Kong issue?
Certainly there was, among significant elements of the Hong Kong protester movement and dissident movement, a great deal of, I don't know if I'd say affection, but certainly gratitude to the Trump administration for what they regarded as that administration being tough on China. Under that administration, the Hong Kong Human Rights and Democracy Act was passed by Congress, something that I think that the Hong Kong protesters were very happy to see. There was the certification that Secretary of State Pompeo made as to Hong Kong no longer being autonomous under that act, which then led to a whole raft of punitive measures and sanctions being imposed on Hong Kong and some of its political leaders. And they were, I mean, to be honest, widely celebrated by some among the protest community and dissident community here. And so I think people were happy to see those sorts of actions being taken, and were there was some concern as to whether an incoming Biden administration, and they of course heard heard over the media the same China Joe sort of slurs that were bandied around. Were concerned as to whether that would lead to some kind of a change in approach. But I think what's been really notable has been the degree of continuity from the previous administration to the current administration in its China policy, including on Hong Kong. And we've continued to hear very strong statements coming out of the administration, out of the State Department in relation to Hong Kong and China. That very notable meeting in Alaska that everyone here in Hong Kong witnessed as well. And I think there is some, I guess, some degree of relief that there's more continuity than change, at least in terms of China policy from the previous administration to the current one. And so I think that's something that people, I think, here are happy to see. In terms of how to constructively engage, it's a very difficult question. I think the world is at a very challenging time in terms of the relationship between China and the rest of the world, complicated by, of course, by Hong Kong. I think had a significant role in bringing the role of Chinese influence to the forefront, and very vivid images coming out of Hong Kong that helped to cement that. We have, of course, the events that are ongoing in Xinjiang, which are attracting a great deal of concern from around the world. China's activities in the South China Seas, issues around Taiwan, and so it's a very delicate time. And I think Hong Kong finds itself really in the unfortunate position of being somewhat caught in the middle. Very much beholden to whatever is decided in places other than here. And I'm afraid I don't have any good advice as to way the Biden administration should engage with China, because it's something that I think all of the world and governments around the world are struggling with, and I think there's probably no one has an easy answer yet as to how to balance the various interests in a way that maintains peace and prosperity for all. So yeah, that's really perhaps the question of the moment.
Certainly. Well, thank you so much again for your time this evening. And again, I want to emphasize for those of you who are joining us that our presenter's book, City on Fire, The Fight for Hong Kong, a wonderful read, is available. It also has at the very top a very nice blurb by Ai Weiwei, a frontline perspective on one of the 21st century's most significant struggles. So again, thank you so much for joining us this evening. For those of you interested, we are continuing our conference tomorrow morning, beginning at 8 a.m. with another panel on the future of Hong Kong, where we will be joined by Professors Michael Davis from the Woodrow Wilson International Center, Eva Pills from King's College in London, and Professor Pierre Landry from the Chinese University of Hong Kong. So please join us for that as well. And again, on behalf of the University of Pittsburgh, the Asian Studies Center, the Center for International Legal Education, thank you for joining us this evening, Anthony.
Thank you. It's been a pleasure.
So on that note, good morning and good evening, everyone. And I look forward to meeting you tomorrow. Bye-bye.